Okay. I think I'm not on. Hello? Am I on? I'm on, but I'm not on. My light's on.
Oh, my light's not on. Oh, it is working. Hello? Hello? Hello?
Bueller, I'm not on.
Huh.
So maybe it's not our best.
Somebody want to call Jerry? Can you try and get a hold of him? Do you want me to have this in case we decide to start?
Oh. So this may not work. Yeah.
Oh,
but
okay.
yeah, that's the problem.
Okay.
So
Hello, hello. No,
Jerry coming?
I don't know. Do you have Jerry's number?
Jerry.
I'll leave this on Lisa's desk.
She's not going to be here. Her daughter's wedding.
Oh, why? I can't imagine why. Good, then I can have some.
But we can leave it on Terrell's. Because Terrell's coming, so we'll put it
Then
there.
I have to get into that thing all morning. Ta-da, ta-da, ta-da. These are cold.
Mm-hmm. How's it getting fixed?
I guess we could do it.
A what? Oh, yeah. Could we do introductions?
Yeah.
Okay, we can go ahead and just do introductions while we're waiting for the mic to get fixed. So we'll start on this end of the room and go like that.
Melanie, I do college. Verily, college teaching. When?
I teach at Westminster, but I'm here for myself.
Okay.
I'm representing the college. Diana Sutherland from here.
Travis Rawlings, USBE.
Terry Shoemaker with the Utah School Board Association, Utah School Superintendents Association.
Cindy Phillips, I'm with WST, and today I'm also with the USSA.
And then
Carol Blair, and I'm a school board member.
David Soleil, USBE.
Sarah Jones, UEA.
Tracy Watson, Sarah Jones.
Sean Moss,
and then. Okay. Oh yeah, we have our. Is it on? Oh yay. Okay, so we do want to excuse Terrell Warner. There was an accident, so she's trying to make her way in, and then Lisa Cummins is out for a family event. Her daughter's getting married. Pretty exciting family event.
For that.
Yep. So, okay, we'll go ahead and get started with item 2.1, R277301. This is the educator licensing. And
Want me to start with
we'll turn the time over to Angie.
All right, thank you. And Travis and Diana are here to help support on this item, and Travis will be describing some of the work that we've done since last month. But just as a recap, you'll remember that the board adopted our 277301 Draft 1 back in May, and then the board filed that with the Office of Administrative Rules, which was out for public comment all of June. And I can't remember if it was the end of June or beginning of July, we had a public hearing, or was it the end of July that we had a public hearing? So actually, the rule was adopted in June and then open for public comment in July. Last month, you'll remember you received the report, the hearing report from the public hearing, and began some discussion of amendments to our 277301. Draft 2 is a draft that includes amendments that were recommended by staff based on the comments that were received during the public hearing, and we can go through that, Travis and Diana and I, to discuss what those changes were. And then also board members Cannon and Lear proposed some amendments, and which at that time the board made the motion to send both all three, R277301 and 303 back to this committee for review. So that's what we're ready to discuss today. If you'd like, we could ask Travis to, and I don't know, Diana, if you're planning to join him, to the table, and we can start with the discussion of Draft 2. Is that what you would like?
Yes, let's go ahead and do that.
Okay. So after the public hearing, Travis and Diana prepared kind of a description of some recommendations and sent those to board members. I believe those are now posted on board docs. I hope they are. But Travis, do you want to start by describing what you and Diana recommended, and then we can talk about draft
Absolutely.
two?
Travis Rawlings, Educator Licensing Coordinator for the Utah State Board of Education. So after the public hearing, we went back and kind of went through the feedback, went through the documentation, and there were several aspects where staff felt there was really good feedback, things that should be changed, and that's reflected in draft 2. Staff has tried to stay as neutral as possible on the more political issues. But one of the things to note, there was some data corrections, some things that were sent to board members. We haven't published that yet. We're looking to very soon, hopefully, but board members have seen that data. But ultimately, draft 2 really goes through and makes minor changes. There's nothing massively changing in draft 2 based on staff recommendations. The major changes, and I can walk you through all of these, and I'll do this very, very quickly. I apologize. Line 25 is the definition of educator preparation program, and as the intent of 303 is to focus on that, in 301 we simply stated that it will mean the same as in 303, so that 303 is the primary location for that definition. The next change is the removal of Section 3. Again, this is that idea that 301 is really going to talk about the licensing structure, whereas 303 will talk about preparation, and so we're removing it from 301, and it's in 303. That was already planned before the public hearing, but that is in there now. The next major change is in several different locations, but I want to give you one example, and that is on line 197. So since the 303 really talks about preparation being more than just university-based, we wanted to make it clear, because as was stated in the public hearing, it wasn't clear what the board meant by board-approved preparation program. So for this purpose, there are several locations, 197 being one of them, where we inserted the language university-based board-approved educator program, so that the board, it was clear that when we were first adopting this rule, that's what it meant, and now that we've kind of evolved, we want to make that absolutely clear. So if you're looking at 197, what that means, quite frankly, excuse me, that if you're going to get a license in special ed and any of these other license areas other than traditional, instructional, you must be in a university-based preparation program. That's what it says. So that's a significant change, and again, it's in multiple locations. And the last change I will mention is in line 258 through 260, and that is basically we removed the recommendation of a Utah LEA because it's no longer necessary. When we think of board-approved preparation program, including LEAs, it was no longer necessary. It's simply you have to complete a program that the board has approved in order to be recommended for a professional license. And that's all of the changes that staff have oh, well, one more. I'm sorry. 316. That's one I forgot. 316 simply, there was feedback that the policy should be posted on the LEA's website. Staff agreed with that and recommended that addition. So that's all of the changes for 302.
Yeah.
Or 301, draft 2, sorry.
Got it. Okay. Any questions from board members for Travis? Or do you want to?
Oh. Draft 2? You can't pull draft 2 up?
No, I can't get in.
She can't get
I
in.
called Jack.
Oh,
So I do have a question.
okay.
Jack. Okay, Travis, I'm sorry, I was trying to get my internet up. So,
I understand.
And you were talking about the university-based. I don't even know what line that was on, so if you could help me there.
The first occurrence is 197.
Okay, I thought it was around 190 something. And then, so, and this is for all licenses?
So, I didn't explain that very well. So there were, in the original rule, the board had put in certain areas the term educator preparation program,
Right.
implying university-based. And it was so someone that doesn't, so 197 is talking about someone who doesn't have a bachelor's degree yet, but is in a program. We wanted to clarify that that's university-based. On line 217.
Okay, stay with me for just a minute right
Yeah.
here, okay?
Okay.
On this one. So on here, under the associate one, though, there are 3 ways that they can get that license.
So those are the 3.
Because you have the CTE,
Mm-hmm.
university-based, and then just the bachelor's degree or higher.
Mm-hmm.
Okay, all right. I just needed
I'm sorry.
clarity on that.
I'm sorry.
Okay, that's really all I needed on that.
Okay.
Thank you. Yeah.
Okay. Any other questions?
I went too fast.
Yeah. Oh, okay. Brittany Cummins.
Okay, so on 169, it begins to talk about, and this isn't even one of the changes, and so, but I just was wondering if
Sure.
you could clarify. An associate educator license may only include associate or LEA-specific license areas of concentrations and endorsements. Have we defined what that means, or can you explain to me what that means?
So when we were going through this process, there was always the discussion of should we keep the structure that we currently have, where we have a license areas and endorsements, or should we, create something new? The feedback and what the board had decided was that we want to stick with it. But essentially, what that's saying is, if I have an associate license, I can't have a professional endorsement. It's like a tiered system. If I'm professional licensed, then yes, I can have professional or associate or LEA specific. But if I'm associate, I haven't met that standard yet, so everything underneath it has to be associate or LEA specific.
Can I follow up on that real quick? Can you give an example of something that can only be attached to a professional license, an endorsement?
So when I say it's not about a specific, like a math versus a science, it's about the endorsement itself being associate or professional level. So I could be, let me see if this helps. So if I am if I'm a math teacher and I'm trying to earn a physics endorsement, I can have a professional license with a professional math endorsement, or professional math, and have an associate physics as well. So I've demonstrated I can do math, and now but I'm learning to do physics. That's the idea.
Okay.
And so if I'm still learning to be a license, I can't have professional underneath. That's really what that section's talking about.
Okay, thank you.
It's very confusing, by the way, so I have to answer that question a lot.
Okay, Board Member Warner.
Okay, yeah, so I want to clarify. So we ran into some problems. Remember when some of the school districts were transitioning from like that middle school area?
Yep.
So I just want to make sure, if we have a math teacher that is teaching, that has secondary ed, as secondary ed, but a math license, and let's say 6th grade is moved from middle school down to elementary school, that person, can they still, like, they have that secondary ed license, can they get, because that's the problem, one of the problems that brought this whole thing up, is that 6th grade area has been, and 7th grade has been bumped from elementary, and then it goes into secondary, and then back to elementary.
And so the way we've approached it in this rule is, again, so you're like you said, you've got a professional secondary. So yeah, you can get an associate elementary by meeting the requirements for elementary. And later in the rule, it actually talks about that if you are going back and forth between like elementary and secondary, you've met the pedagogical performance assessment already. It's just about having the experience doing the program, and then that's where the LEA-based programs come in. So, if I'm that LEA, then I need to make sure I have a way of making sure that person knows how to teach in elementary.
Right.
And so that's my program that will help them get them there from associate to professional in elementary, if that makes sense.
Okay. Okay.
Okay. Seeing no other questions, we'll go ahead and excuse Travis, and we'll invite board members Janet Cannon and Carol Lear. They have some recommended changes to this rule, and those are found in draft 3. And draft 3 also contains the staff recommended changes as well. So it's got them both in there.
In different colors.
Yes, in different colors.
Colored photos. Let's see. So Angie has prepared these for us so we can address those.
So
Oh yeah, make sure.
just to clarify, all of the amendments that are on this page are also in draft 3. They're just 2 different formats for people to follow if it makes it easier. And they're both, this document and draft 3 are on board docs.
Can you tell me the color code different, which is which? So the ones we'll be addressing are draft 3, and they are in green text. Green.
So green and purple.
So the first thing we looked at was after line 258, and this is,
It's at the very top.
oh, excuse me, you're right.
Oh,
222, yeah. So this involves just a minor word change. So draft 3, line 223. We are talking about successful completion of professional learning modules established by the superintendent. We just felt like that was a stronger word to empower the superintendent to say, these will be the things that we're looking for. So it's just wordsmithing.
So, can we ask questions as we go, or are we going to have them present and we'll ask questions?
yeah, let's ask questions after, well, okay, after each amendment, yeah. Intent of what? Oh.
Okay, so I'm curious about using the word established. I know wordsmithing gets funny sometimes, but when you say she established it, it almost feels like she has to create it. And so that was kind of why we separated created or approved, so that the superintendent has the flexibility to either create something or approve something that isn't created by USBE. So I was just curious if why you feel the word established would actually strengthen.
I think when we came to this rule and looked at it, I think, at least for me, one of the things that I felt a responsibility about was that we as a board have a responsibility to our constituents to provide the best possible teachers we can for students. We know teachers are absolutely critical for student success. And when we came to this, I created or approved, I think we didn't want it to be something that was outside the realm of the superintendent. I thought we wanted that closer to the superintendent so that we knew exactly what was going on, because these modules were being established by her and not created somewhere else or approved somewhere else.
Can I just add one thing? And believe me, we won't have to repeat everything twice. But this was kind of, that goes to the core of what my concerns were, and that is that I absolutely, I know that Terry and Royce Van Tassel wrote very eloquently about trusting LEAs, and I absolutely trust LEAs to hire. But I feel like if the individual wants a state-approved license, if the license comes from the board, then the board has to take the responsibility to have some control over that and set some standards. So for me, established means that the board will do that. It's not, it doesn't mean that the superintendent wouldn't consult with LEAs, take some of their ideas, make it part of what she sets as those standards. But I think it goes to the core of the board needing to take the responsibility for a license. St. Mark's would not very well license doctors and have the AMA say, oh, for sure, that's a doctor for us.
Okay. So, can I ask a follow-up question, Michelle? So this particular line is in regard to the modules only,
Right.
and part of the intent wasn't that LEAs would be creating these or whatnot, but it would be something that the superintendent has control over. But what if she wants to send out an RFP for someone else to create this product? And so I'm worried about the word established, where it almost gives a feeling where she actually physically in this building, USBE employees have to create those modules.
And I guess I don't see it that way. I see it as something that is her oversight, her doing. I think created I could live with. Approved suggests to me that somebody brings it to her, and any LEA brings it to her, any other person brings it to her. Created is also acceptable to me, but I wanted the message that the state is set, and I know it's just to do with the modules, but they're kind of central.
Okay, sorry, I don't want to belabor it. I'm worried that we'd be tying her hands in her ability to really do what you're saying you want to have happen, because I agree with you entirely that this is the responsibility of the superintendent, is to make sure that these modules are top quality, and that and we talked a lot about the word modules, right? Because we wanted to communicate the importance of this part of it. And so I'm just worried that actually establish might tie her hands in her ability to really create or to really approve, to look at closely and to say this is something that
What about
you would
adopted?
use.
I just think approved suggests it comes from the LEA. And again,
But
no
she still has to
offense
approve
meant.
I feel the same way. I think it's the word approved that is troublesome for me.
But I'm fine with adopted. If you can suggest a different word that says she
still has to
finds
approve it.
something else and embraces it, then
If
that's
she wants to create them, that's fine. I think that might be more troublesome for her than established.
If I might, I think that there's two. So established, I do think that the superintendent could contract out with somebody else. But the issue is, if somebody wanted to create their own modules and then have it approved, I think that's where you're now taking that option away,
Right.
which is different. So I don't know that established ties her hands in being able to contract out for something to be created, but it doesn't then allow, let's say, JUAB has created some modules, and they just then want the superintendent to say, will you please approve these as meeting the standard you'd like? That's when you would probably want the word approved in there.
Yeah.
So
But it wouldn't stop her from saying, JUAB, you have great ideas. Let me make that part of what I already have, which I very much approve. But I feel like
think it
the
does.
state has to take responsibility for its own license.
I just worry about the cost effectiveness of that, where you say somebody has something and I really like it. It's really cost effective to say I approve, but to say I really like what you have, let me duplicate that or redo that, or
yes, I hear you. And Janet can speak to that
Yeah,
too. But
I don't know. Do we really want to be cost effective in terms of providing teachers?
But the
I mean, I
result
think
would-
that's
oh,
what
sorry.
the one place where most of our money is spent.
Okay.
And so I would like the superintendent to have oversight of what this means for our teachers.
I'm fine with adopted. Do you like that better, Brittany? Does that speak to you any better than approved? I just feel like there needs to be more state involvement than it's our proposal, so you can certainly take the lead.
Okay.
All right, thank you.
Okay, we'll move on to the second amendment for line 258.
Okay, 258, this is regarding the professional educator license requirements. And we just added that the professional educator will have completed a bachelor's degree or higher, or a skills certification in a specific CTE USBE area as established by the superintendent. So those are for our professional licenses.
Already in draft 3. Oh, yeah, okay. But I didn't see it in the two other ones.
It was.
Yeah,
because
this
that
is
was it.
their changes.
Yeah, they're
The green and purple is,
Oh, yeah.
These are our proposed
Okay.
amendments.
yes, Board Member Brittany Cummins.
So the line before it says all general requirements for an associate educator license. Don't both of those, aren't they already in the general requirements of the associate?
It's,
Travis,
it's,
do you have that answer? Oh,
well,
I saw him raising his hand. Go ahead, Carol.
it's a,
Well, I don't know the answer to that, but I just wanted to let you know I have a question after.
Okay.
in the associates, it's an or. You can have the bachelor's, you can have the bachelor's degree, a skill certification, or you can be enrolled in a university-based program. I think there's a fourth one, too.
It does
So,
be the
so
same.
if they filled all that, all the ors in the
Well, no,
associate,
but they could just be enrolled in a university-based program. Could be one of the associate requirements. That would satisfy the associates, and you wouldn't have had one of the other two. Do you see what I'm saying? If there are three, and this is,
so this isn't repetitive?
I don't
Okay.
feel like it because they'd have to do, to be professional, they'd have to do A or B, not A, B, or C.
Okay, Travis, can you come to this mic over here? Sorry.
I'm really trying to, yeah. Just very quickly, when we discuss this in the associate, it talks about enrolling in a program, and professional never says anything about having completed it. So theoretically, the way it's currently written, you could be enrolled in a program, then somehow not get your bachelor's degree, and
Be an
so
associate.
theoretically, in practicality, that's a whole other issue. But this makes it clear that you have to have completed that bachelor's degree before you get your professional license.
Got it. Okay.
Okay.
And then did you still? That took care of it. Okay. Okay, then we'll move on to Amendment 3.
Amendment 3, so lines 297. And I think I'll let Carol speak to this one.
This was a concern I had. I feel like Travis, I've had these discussions with Travis for what, a year and a half, maybe. And he's been very patient. And one of the concerns I've had is he's said we need a release valve. We need a place where if there's a unusual circumstance that where the person's truly prepared, that she could go and my feeling was this would have solved some of the other problems some of the other more complicated procedures that have been put in place. But it was very important to me that it be objective. It be an objective review panel. And Travis, I think, wrestled with that because he does know a lot and he's an expert in the area. But this would just establish a review panel that had some objectivity, not just people under the superintendent or under Travis who were sort of confirming or reaffirming those decisions. Okay, I have a question.
Okay, Board Member Warner.
Well, would it be better, okay, so we have this at 297 to 299, but I'm trying to think of a scenario. Would it be better to put this instead of under the professional educator license, under the associate license? That little area? Because I'm trying to think of when somebody would have a professional educator license and they would need to appeal. I'm thinking that would be more with somebody trying to get an associate license.
No, actually,
Did you think in a different?
I'm thinking that, having said what I said earlier about this is the state's responsibility. If you want a license, then the state should have responsibility for that opportunity. But I think that there are some people, some situations that are so exceptional that could maybe demonstrate. I've taught in public schools for 30 years. I was licensed long ago in Alaska, never finished A, B, or C. I'm just exaggerating for effect. But I've been Teacher of the Year in North Dakota, and I think I should have a professional license, and you're only willing to give me an associate license, and it may be symbolic. It may have consequences for salary, but that I think
Okay.
there should be an opportunity for an exceptional person to have an objective review and even be able to get a professional license.
So do you think that should also apply on the associate license? Because I'm thinking of like the bizarre case of that woman that taught for like 30 or 40 years in Mexico, and she comes here and we're like, sorry.
I thought that there,
And maybe I'm wrong,
If
but-
there's an oversight here, I think that there absolutely should be that opportunity, but I thought that there were more flexible possibilities
Tra-
Okay.
for the associates. But Travis, can you?
Yeah,
Would you like
I'm
me
just
to
going to
stay
ask
here?
you to stay. Yeah.
Yeah. Okay, Lisa.
One of the things to bear in mind is that this particular amendment, the appeal process, the idea of an appeal is already in the rule that was
Okay.
established. What's being proposed is a change in who makes that decision.
Okay. That's right. Okay.
That's a lot simpler way to
Yeah.
say that. Sorry.
Yeah, thank
Okay.
you. That makes it, yeah, that's right.
Okay. Oh, yes, Board Member Brittany Cummins.
Sorry. The appeal process, is that just that line? Are we describing the appeals process there, or is it somewhere else?
293.
290,
Just a little bit above.
So like the woman.
so this panel would then give their recommendations to the superintendent, who would make the final decision? Okay, and is the superintendent required? Implementation for approval by the superintendent for review and approval. The superintendent shall designate a panel. So I'm just curious what the responsibility of the superintendent is based on the review panel's recommendation.
That's a good point, because I think this is my weakness in rule writing. I always write approval when I mean approve or deny, because you wouldn't want to tie the superintendent's hand. They should be able to approve or deny based on this. So that's probably a wise change.
And
to
I'd
that
even
language.
build in maybe a presumption, so that there's a very strong suggestion that if this panel recommends that the superintendent should take it. But consistent with what I said earlier, I don't think her hands should be tied. But maybe make a note of that if we have an opportunity to discuss this again, Angie, that maybe that if there's a presumption the superintendent will accept the panel's recommendation, something like that would be my druthers.
Okay. Yes,
Can I
Angie.
just ask a clarifying question? You'd think I'd know, since Travis and I and Ben and others who wrote this. But do we want to say then that the superintendent is not actually doing it? The appeal panel makes the decision, or are we saying the appeal panel will make a recommendation to the superintendent?
Recommendation.
Because if we could make that clear, so we could say on 299 to review an appeal and make a recommendation to the superintendent for her review as described in subsection 9, and then we'll add approval or denial on 295. Do we like that?
Yeah.
We can
Yes,
make
I like
those changes.
If it's again, if you're asking me based on our amendment
Yeah.
proposal, I'd like the presumption part of it in there too. So it's a presumption that superintendent accepts the panel's
I don't.
recommendation.
That ties her.
Okay. So we'll move to Amendment 4.
No.
Oh, Laura.
Okay,
Sorry.
I would just like to go through this. You'll just have to help me a little bit. Okay, so somebody that comes and applies for a license, they're quote unquote out of the norm, so we have to do a little tweaking. Okay, so, and then they end up into this setting where they don't fit into the boundaries. Okay, so my question is, what's their first step, second step, third step before they get to here? What happens first?
So if we model this after, reasonable current practice, essentially the person has to have exhausted all other avenues. So that to say, here's why I can't be an associate, here's why I can't, or here's why I don't, if they do a review and we say, well, you need this pedagogical performance assessment, it's at that point they'd say, well, I don't think I should have to do that, and they make their appeal and go
So
from
then
there.
oh, can I follow? So you have this line and they don't fit, so they come over here and they end up here. So they come over here and do this. But then if they did the pedagogical review and they still are out of the norm, then they just keep going down here until they finally
Yeah,
jump over
yeah.
there. Okay.
Yes, I mean, the intention is if they meet the requirements, we want to give them, there's no difference in this license and somebody, it looks exactly the same.
Right.
It's just that they were appealed and were given it under different circumstances, essentially.
Okay, I have one other question. Okay, so you said they've exhausted all of their options.
Mm-hmm.
That's clear up here on number 1 now. We're clear up here, not down here. What are all their options? To do an associate's, to do a professional, to do an LEA?
I don't think we consider LEA an option just because the purpose of this is to get a professional, and LEA is very different than that because it's restricted. But anything like if they were to say, they'd have to say, I'm not saying this very well. The intention is that, yes, they'd have to show that associate stuff is unreasonable or untenable for them. That's the language we offer.
Okay, and if it is, then they could go to their
Yes.
LEA.
They theoretically could. I mean, technically, if they went to this appeal and the appeal says no, we still don't think you should have a license, they could still
But
do
do they
LEA.
have to go through the appeal, or
No, they don't have to.
So they could go here to the
Oh,
LEA,
absolutely.
or
If that's what they
Yeah.
choose, yes.
That's
Okay.
what I need.
It's just, I wanted to route to get a completely full-fledged, golden starred professional license for the unusual individual.
Okay.
I was just trying.
Okay, so we'll move on to Amendment 4, which is on lines 319 and through 331.
Okay, so,
319.
yeah, so, yeah, so this is regarding the LEA-specific license. And one of the things that people were most concerned about, and it came to me seeking, was we previously had this language in, and it was taken out, and we'd like to see it put back in. So this is the language that says, the LEA demonstrates that other licensing routes for the candidate are unreasonable or untenable. It just kind of puts some guidelines around, this is not some warm body that we pulled in off the street. This is someone that we feel really has capability as a teacher, but doesn't meet the other qualifications. So we added this that was informally, the LEA demonstrates other licensing routes for the candidate are unreasonable or untenable.
I have a question. Do you want her to finish the whole thing? Oh, but it's on that area.
That's all. I think that's. I think
Is
she's
that all?
finished.
Okay.
Mm-hmm.
So,
Well, for Amendment 4.
yeah. Do I get to, okay.
Yes.
So
go for it.
tell me how the LEA demonstrates that, or should it say something like to the effect of the LEA indicates? I'm just,
You don't like that demonstrate.
no, because I'm not sure how we demonstrate, how an LEA would demonstrate. I just think they can say, hey, listen, check box, it's not working. We don't have anybody. I don't know.
I don't have a real hang up on the verb, but
Okay.
an example from there's a case near and dear to my heart at Clayton Middle School where there's a fabulous drama and dance teacher who she's probably 50 something now. She's been teaching there for 20 years. She has the equivalent of an LEA specific license. I think they call it something else. But in my mind, demonstrating that she doesn't want to go back to school. She's been doing this for 20 years. She's at a point where she's demonstrated her abilities and capabilities, and it's unreasonable to ask her to go back to school. She doesn't need to. She's already come through.
So would you want the LEA to just write something up?
Uh-huh.
Okay.
And provide their explanation.
Yeah, an explanation.
And I don't even care about documentation. But, that dance teacher's not going away. She's fabulous.
It's kind of
She
like
should
when
be.
Logan High tried to hire a physics teacher and they got a professor at USU, and
Yeah.
yeah.
And
it
I
was
don't
a
care
nightmare.
I don't want to make this labor intensive where you bring in 5 degrees and 15 affidavits. Just you explain to us why you think that this route is one that satisfies you.
Travis, did you have something more to add?
I just wanted to say that in terms of an implementation point of view, this language implies, at least to us, at least to me, that we are passing judgment. If it says that the LEA demonstrates that other licensing routes for the candidate are unreasonable or untenable, that means that we as staff have to pass judgment on what they're saying that it has demonstrated it. So that is a judgment piece, whether it's, whatever verb you use, this is saying there's a judgment going to be made. That's what it says.
Is there a verb that you like?
I think the verb is immaterial. It's the idea that if you want us to make that judgment, we're happy to do it. We do it now, like you mentioned.
Right.
But if you don't, then I wouldn't even put it in.
Okay. Board Member Brittany Cummins.
Well, that was exactly what I was going to say is what boundaries are we going to put on Travis to be, the czar deciding, nope, that's not, you haven't demonstrated enough, or I see this pathway would be better and easier. And so I guess my question is what is the necessity? What is it going to really accomplish? Other than I agree with the emphasis, and I think everyone agrees that this LEA specific license is for those moments, right? When you have a situation that doesn't fit in anything else, and I think that's the purpose and the use of it. And so I'm just wondering, what does that mean if it puts the USBE in that position to make that judgment, or are they just going to always be like, okay, thanks for the info, and we're always just going to say okay, and then it's just a hoop?
In my mind, it's there's subjectivity in it now, and there'll always be some subjectivity in these sort of outliers. And I'm very comfortable, for the most part, with the decisions that they've made. They're seasoned administrators. I think there's value in articulating, for the LEA to articulate, this is why, and my dance teacher description is the best example I have. I have some others.
Okay.
Oh, I think Angie had something.
Oh.
I just wanted to mention that in some ways, when you do have the standard, it does make it less subjective. Either the LEA or our office. I mean, one thing you just mentioned, I'll just use the dance teacher. Is it unreasonable and untenable because she's 52 versus 32? I mean, that's going to be really hard. You can't really use that as the reason.
More because she's done it for 20 years.
Yeah.
And successfully.
But I
point.
think that to think about this in the future, though, that she wouldn't have necessarily been able to get it 20 years ago, though. So she's been working under an LEA-specific license, which currently doesn't require that. So you could be closing the door for some of these dance teachers or anomalies to get into the system. I'm just trying to think, because I don't, and Travis, you may have some experiences of where you've had to deny something, and LEAs have either been afraid to issue these licenses because of something like this. It just does raise a legal standard of why, for example, let's take Michelle and I, because I don't think you're a licensed educator, neither of us are, but let's say, why would you say that, and let's take Juab, for example, wants to hire both of us. Why is it unreasonable and untenable for her to get it, but it is for me? You're now going to have put that LEA in a position to say, some people who are coming to us that may fit the LEA specific, we're not going to make you go to school, or we're not going to, and others you will. So just remember that they will have to go through a process of determining between the different educators that come to them. And there could be some legal liability of equal protection, if they make those decisions based on gender or age or, anyway, I'm just raising that as an issue to consider.
Okay, we'll go to Board Member Warner and then Belknap.
So on this, with the LEA demonstrates, or whatever word, that the licensing route for the candidates are unreasonable or untenable, are you thinking that it would be up to the licensing department here to approve that? I'm just trying to figure out, because,
I thought that was my thinking.
Okay.
And I think it exists now. That's what
they do
the
now.
language says that now.
Right.
So,
Okay.
and they've been doing that for years, and I'm very comfortable with that. Again,
Right. So
everybody has a little bit of difference. I guess I differ with Angie a little bit that it creates much legal liability, because I think that the person is asking for a gift of sorts.
Okay.
And so I don't think that creates that kind of legal liability, and I think that it's up to the LEA to express it. I think the approval process by the USOE is,
Okay,
I
so they
think,
would be
pretty
responsible.
formulaic, is what I'm saying, but value in articulating
Okay.
why we want this route rather than other routes.
Okay, thanks.
Okay, Board Member Belknap?
I know that we're probably not going to make a decision because we have other people who want to talk on this, but a couple of things. I appreciate the fact that the LEA needs to articulate why they want to do this. I think that and so I'm not sure it's even a request or demonstrate. They're just saying, we want this, and if you have any more questions, you can contact us about it. The other thing I like is that it's not on the back of the educator, which it is now. They are going through 10 million pieces of process, years of trying to get an LEA-specific license. And so those are pieces, but I'm not sure exactly how to have that happen, and so that could be some further discussion.
I have one other thing for so with the LEA specific, Travis, and I can't remember because my brain is not working today because I'm old. But with the LEA specific, doesn't the board, that local board, have to approve the application?
Yes.
So would that be?
Maybe they could demonstrate.
Yeah, is that where, like, if the board, their local board makes the application to the state board, they've articulated that, I'm just going to use Sid as a principal, for example, at an elementary school, and let's pick on Juab again, and she needs somebody, and she finds the dance teacher, and her board, that local board approves it. Is that sufficient for Travis to approve it, and is that?
I like that thinking. Giving that back to their board to ask.
And my feeling is, though it seems like a bit of the board approves it, but this goes back to my basic premise. That's why I raised that to begin with. It still has to come to the state.
Right. No, I'm just wondering if their local board recommends it. Is that sufficient for demonstrating?
It would be for me, but but the articulation still goes to the state for the state's review and acceptance.
Because in reality, the state is the one that is issuing a license to this person, even though it is an LEA-specific license. It is the state that is giving the license.
When we started this discussion, I actually proposed to Angie and Travis, you know what, I'd rather just do away with licensing and say, you know what, if the districts want to hire people, great, I trust them explicitly, but I don't want to put a state stamp on something that the state doesn't take control of.
Sorry. Okay, we're in a big time crunch, so let's move on to number 5.
We can move faster. Right, Janet?
Oh, we want number 5?
Yes, number 5.
Okay, so the LEA-specific license, we did a little wordsmithing and used the word candidate throughout here, so it would be the same. The candidate has successfully completed the professional learning modules established by the superintendent, and we list there the learning modules. And then Amendment 6, the candidate satisfies one of the following: a bachelor's degree, current enrollment in a university-based board-approved education prep program, skills certification, or if they have 4 years of documented occupational experience within the last 10 years. So that picks up your music people, your dance people, whatever, your eminently qualified people. If the candidate will be assigned by the LEA to teach a core subject, the candidate has passed a content knowledge test approved by the superintendent. So if you are bringing in someone to teach math, if you're bringing in someone to teach one of these core subjects, we have those content knowledge tests. We'd like them to have passed at least that to be able to teach.
That's number 7.
That's number 7.
Oh, sorry. I'm moving too fast.
No, you're fine. And then if you want to do number 10, and then we can ask our questions. Oh, sorry, 8, 9, and 10.
But we didn't do 5 ever.
Yeah, she did 5.
Okay.
Oh, all right.
So, so then since we are asking them to, if they want to teach a core subject, back in the definitions, we added a definition for this, what core subjects are. Okay, then an LEA-specific license or endorsement is valid for 2 years. So the associate's license are valid for 2 years. We just thought this would add some consistency. It gives us an opportunity to give these people tryouts. They will be mentored for 2 years, and after that, they would come to the board for a renewal that could be approved or denied by the board.
Okay. I do have a question. So I'm looking at all of this, and I'm looking at your Amendment 4, and I'm pretty okay with it, changing a few things, but I'm pretty okay with it. But all the others, it feels like now if they're going to do all of that, they may as well get an associate license. Like, it just feels like the point of the LEA specific license, as you stated here, is to say these things are unreasonable or unattainable, but now we're I just feel like we're now, let's go get an associate license. So I'm trying to.
We would like that.
No, but I
Oh, I'm sure the LEAs also
and I
would
also
like.
think that, and I heard Terry whispering exactly, and I don't think that is exactly true. Line 338 on Amendment 6 actually still allows for the 4 years of documented related occupational experience. So it really does leave it broader than going to a program. You've been a auto mechanic for 4 years, or you've been a copywriter for 6 years, and you would be excellent at being an English teacher, something along those lines. I think another important thing to mention about number 10, though, is this is a parent's rights. This is a parent information piece that would have all of the LEAs listing the licenses that their educators have. And that's public information anyway, their credentials, but it would be more explicit and allow parents to then see what kinds of licenses that LEAs had for their employees. So.
Okay, Board Member Brittany Cummins.
So a question on, so the one thing that's different under this amendment on LEA specific is that 4 years of documented related occupational experience, which would be interesting. I mean, so if you talk about the dance teacher, was she occupied and documented as
she taught dance for a number of years in her home.
In her home, and so
before she went.
So
before
that's
she taught
considered occupational and documentable.
I don't want to stress too much over the words. I know that they do matter, but I think she could sign an affidavit that said I taught dance for 10 years. That was before a notary and supposed to be a sworn statement that would then satisfy documentation.
So a home ec teacher who's had 30 years as a parent, sewing and cooking, and so is that occupational and documentable for a home ec instructor?
Again, that's the level of subjectivity in my mind. If she would take pictures of, bring in 5 items that she's made, show that she's, I had those same number of years, but I've never sewn a thing, and since home ec in 9th grade, so I couldn't myself be a CTE teacher. But if you could show that you've had a sewing experience and successfully, and you've made X number of items, and here are some pictures of them, that to me would be documentation.
One other question.
Yes.
Sorry, did you?
I'm waiting.
Okay, one other question. So under Amendment 9, it talks about at least 2 years, which I'm curious about why you put that in there, because the associate license doesn't have a boundary of time established on it. And so how would that fit in if they're required to have this mentor for 2 years if they may not be an associate educator for 2 years?
I'm not sure I'm understanding.
Oh.
Am I?
No,
Okay, so this was the question about mentoring that we were talking about yesterday. So we thought these LEA licenses can be renewed and renewed. So the question we were trying to deal with here is when you have an LEA-specific license, the LEA is required to mentor you, and you would have that license for 2 years, so you would get 2 years of mentoring. What we wanted to say by adding these words was that if you are continuing to teach on an LEA-specific license after those initial 2 years, the LEA would no longer be required to provide you a mentor.
I was trying to unburden.
Yeah, we didn't want to saddle LEAs with the responsibility of mentoring those people ad infinitum.
Sorry, just a clarification. So this only applies to the LEA-specific license? Or are these requirements
like
for
it does.
LEAs?
Yes, Angie?
Yeah, so the at least 2 years would only apply to educators who have an associate or LEA specific license. And then the LEA needs to be providing a mentoring plan for all of their professional educator license holders with less than 3 years of experience. So I don't know if that's helpful, but what I heard from you is, are you saying what if they only have an associate license for 1 year? Does that then require the LEA to keep them on for 2 years? I wasn't sure if that's what I heard from you. But because I think that what Board Member Kennan is trying to state was actually the opposite. Let's say that an LEA has somebody on an LEA specific or an associate for 4 or 5 years. They were actually trying to state that you may only have to do the mentoring plan for 2 years.
Yeah.
That's maybe we need to.
Okay, we'll have to look at the
Yeah.
wording on that.
But the point was that the mentoring, the required mentoring should not go on forever, was our thinking.
Oh, okay.
And if it needs, and our thinking was it applied both to associates and to LEA specific.
Okay.
And if there's a better way to say it.
Okay.
So,
Okay, thank you. I guess you've got your committee to get to.
Thank you.
And
thank
We
you.
will-
Thanks
your
for
time.
your good questions and your patience.
Thank you for coming early after a late night.
okay, so we'll move on to public comment, and we do have a hard stop on this at 10, so or around 10. And we have 3:03 to also go over. So we're going to have public comment for 2 minutes. And so we'll have Cindy Phillips, and then Terry Shoemaker will be on deck.
Thanks so much. I'll be very quick then. I want to state unequivocally that from where I sit as the director of a charter as well as on a review committee with the USSA, that draft 2 is highly preferable to draft 3 in just about every way. I want to suggest that the appeal process is wonderful in both, and particularly with the adjustments. But I also want to suggest that there are some problems with draft 3. Essentially, if you look at the stipulation in the LEA-specific license, that a candidate has successfully completed the professional learning modules established by the superintendent. But what you have, if you're an LEA in a position where, as I was this year, you've offered to 5 different people a middle school science position and have been out salaried by others, including Wyoming, then you are very grateful that there is an APT candidate that will take this who has extensive chemistry content area in her degree, and you are also really excited that she's going to take the CUSE and NUSE modules, which have been highly respected. But obviously she was hired in August. Now she is starting them. They are not going to be completed. So the fact that she's concurrently being mentored by our people as well as taking these modules allows us to either hire an LEA specific or, in this case, an APT candidate with the current licensure paths, so that we don't have a long-term sub in there or someone without content area expertise who is getting pedagogical expertise. I think that I don't see where the exception is in the copy I have for a bachelor's degree or higher from a regionally accredited institution for an LEA specific. And I think that you would have to absolutely state that in language somewhere so that vocational people could be hired. I also think on draft 3, the idea of concurrent enrollment in a university-based board-approved educator preparation program that will result in that bachelor's degree is redundant if the individual has a bachelor's degree, and is prescriptive if the individual doesn't but has occupational specific skills. I'm also concerned
Your time
about...
is up, so if you can just wrap
Yes.
up. Thank you.
I'm also concerned about the 4 years of documented related occupational experience within the 10 years prior. And the content knowledge test I also think is great for 90%, but not necessarily for the occupational. I would encourage flexibility that I think is found in draft 2. Thank you very much.
Thank you. Terry Shoemaker, and then Royce Van Tassel. You're on deck. Yes.
I'd appreciate, Cindy, if you wouldn't mind writing those comments up. That would be helpful to have them side by side as we work. Would that be okay? Thank you. Yeah, and then I could pass it out.
Okay.
Terry Shoemaker with the Utah School Superintendents Association and Utah School Board Association. It's a fascinating conversation, and it seems like we've been having the same conversation now for years. That ought to be a concern to you. Why can't we get to a decision on this? Because it's creating confusion in our systems. We need to get to a decision. It is an important conversation at the same time. So when I say that, I mean that sincerely. I asked Travis a few minutes ago how many AP teachers, and I could have said ARL, special license teachers we have, and it's when you put them all together, APT and ARL, it was over 1,000. How many total teachers do we have?
Teachers would be near 30,000.
Okay. So we have a lot of teachers that are participating, trying to get into an endorsement program. A significant number of people. In my own school district of Wasatch, when I was superintendent, I was shocked when I got the data about how many were ARL or APT. As I was looking through that, again, I want to say again, our preferred method is the traditional university course methodology. But we're not in a preferred time. We're in a national and state teacher shortage. We also have our university programs producing less qualified teachers. They're doing a great job with those that they can have in the program. When we're in a teacher shortage, when we have great programs, and we have to figure out ways to attract people to teach. Otherwise, kids don't have programs. For example, we talked about the dance teacher situation. I'll just end with the Duchesne situation I talked about before. We wouldn't have a music program in Tabiona if we did not have the teacher there on an LEA-specific license. That affects kids all over the state, particularly our smallest school districts. I urge you to use draft 2 as the way to move this forward. We need to settle this issue. Thank you.
Thank you, Terry. Royce Van Tassel, and then Melanie Agnew. Thank you.
Morning. It's always fun to be with friends. Royce Van Tassel, Utah Association of Public Charter Schools. I think it's important to think about really what the alternative for that charter school director or the superintendent or the principal becomes in the event, as both Terry and Cindy indicated, that you're left struggling and something has been ratcheted down so tight that getting an LEA-specific license doesn't work. The alternative for that becomes a long-term sub, and that is a less effective strategy. But if we push the standards there in this admittedly rare circumstance that folks are going to go through LEA specific, that's where we will unfortunately end up. I have spoken to a host of charter school directors who say our preferred option is always to go through the traditional route. There are circumstances that simply don't allow that. And if we make it that much more difficult to use an LEA specific, then we end up in an even worse situation with that long-term sub. So thank you.
Thank you, Royce. Yes, Board Member Belknap.
This is actually, several people have said that it would be worse to have a long-term sub. What would be worse to have a different sub every day because you can't get a long-term sub.
True.
Yeah.
Okay.
That does happen.
It does.
Okay, Melanie Agnew, and then Marilee Coles Ritchie is on deck. Yeah. Yeah, that's fine.
Good morning, everyone. Thank you. My name is Melanie Agnew. I'm here speaking on behalf of myself. I do want to say, however, that I work at Westminster College, so I have access to some documents that you have in front of you. What you have in front of you is a rubric. It is based upon 10 Utah education teaching standards. These standards have been developed by the board, and I want to commend them on some really fantastic work. So teachers who go through university-based programs have to demonstrate these 10 standards. So I think it's important to say, what is a standard? Standards are indicators of a level of quality or attainment. They can be used as a norm and used for comparison. So these are important because every university-based student goes through and demonstrates their proficiency, and they're not put in front of a classroom until they have done that. When you look at this, it's important to look at it as a developmental progress, so that when students graduate, they have attained one of these 2 levels that are on the right-hand side. There's 10 of them. I don't have time to go through them, nor would you want me to, but I do want to look at least one. So if you turn to Standard 7, for example, it addresses instructional strategies and attainment levels for that. Standards will get to some of those concerns and questions you have around the home ec teacher and the dance teacher, because it allows you to measure a level of performance, to say you are proficient enough to teach in front of a classroom of students. And ultimately, we want not just long-term subs, but we want proficient teachers in classrooms. We all want that. We know that, and we know there's a teacher shortage. So we need to wrap good policy around this. Instructional strategy number 7. The teacher uses various instructional strategies to ensure that all learners develop a deep understanding of content areas and their connections, and build skills to apply and extend knowledge in meaningful ways. This is really important. It's not just that, but there's also 7 subsections to that. And it's important to know that our teachers develop these 10 standards. It brings upon us an equity question.
If you can wrap up, please.
Yes, so I'll wrap up with this. Who decides which K-12 students get teachers who have demonstrated these standards developed by the board, and who decides which K-12 students do not get teachers who do not demonstrate the standards? Thank you.
Thank you. Okay, Marilee Ritchie, and then Sarah Jones is on deck.
Marilee Coles Ritchie, and I'm here on behalf of myself. I'm a teacher, educator, and a parent. So I have a few questions about the indication of the associate and the professional, and if that can be. I know we've talked a little bit about there might be a list of who has the professional and who has the associate. The reason I'm bringing that up is there's been a little bit of a trend of Title I schools getting more teachers that are going through the alternative licensure route or the APT, and that, of course, brings up an issue of equity. So can there be a limit in certain schools, and how does that go about? So how will parents know that they're getting a teacher that's an associate licensed teacher or professional? And that's based on, do these teachers really demonstrate that they know the 10 standards? Because the board has said these 10 standards are what we want to have. And so is there one of those standards that you're now saying, no, I guess that standard is not as important as we said it was? So if you're saying, yeah, we have to have a warm body in the classroom, so we're just going to forget that this standard is there. Does that make sense? Because they haven't demonstrated it. So the modules come into play because it's still unclear how rigorous and the duration of those modules. I think there's probably some really great modules that are out there, and there's probably some that are not so great. And so the superintendent decides that. And do those modules really speak to those 10 standards that everybody has said we need to have teachers who are able to meet those. Then it goes back to the question of teacher shortage, and I think we're like trying to play catch up rather than doing some really creative things about scholarships, about getting more teachers who want to go in the field on the front end, who go through what everybody says they prefer, and that's a university-based program. So how can we create a system where more go through that in the front? So that's other work to be had after, but I prefer draft 3 because I think it meets more of the 10 standards that we've all said are important for our students to have. So, thank you.
I repeat again, would you write those down and send them to us as well? It's very helpful to have them out. Thank you.
Okay. Write what down? I'm sorry.
What's your comment?
Oh, yeah, sure.
Anybody who would, sorry.
Yeah, if anybody can send in their
them in.
comments,
Okay,
that also helps a lot. Okay, Sarah Jones and then Rita Hagren.
Good morning, Sarah Jones with UEA. We also prefer draft 3. There are some things in this draft that every time I read this catch additional things that are unintended consequences, like the kind of ongoing mentoring requirement for LEA specific when that really wasn't the intention. So there are some critical things in draft 3. Let me just address 2 things though. This idea of the LEA specific being used only in a rare circumstance, or really they prefer the traditional route, that's how districts would prefer to hire. We understand that and recognize that. When the APT license was created, it was described numerous times as being applied to really only a few dozen people. That's really all we need it for. And there are literally hundreds of APT applicants right now, or APT licensees. So it's really imperative for the board to think through what is the best practice in licensing for our students, and what are reasonable standards for the board to set for every single license, because the LEA specific license is a state license. You are responsible for the LEA specific license, regardless of how the LEAs decide to set requirements for applying for that license. It is a board issued license. So what is the standard you wish to set on that license? And let me just bring you back to the current requirements, and Travis can correct me if I'm misstating this. There is currently a version of an LEA specific license. And all of the things that are added in draft 3, as I understand, are currently required, and unless you adopt draft 3, would not be required for the LEA specific requirement, or LEA specific license, including demonstrating that the route is unreasonable or untenable. That's current language. Having a degree, that's current language. Having a content test, that's current language. And removing those requirements is lowering a standard, we would argue. So please consider that. The other thing that I'll just point you to is on lines 396 to 397, because I think there's perhaps a misunderstanding about the data reporting, and I'm on draft 3, lines 396 and 397. So there is some data that's being required. There's an amendment, there's existing language about reporting on license types. As I read lines 396 to 397, it's not saying that every school reports on educator licensing. It's saying that if you have an LEA specific license, then you're obligated to report. So is that the intention, that you only want certain schools to report licensing, or did you want all schools to report licensing? I think that's a point of confusion that I wasn't clear what board members Lear and Cannon had expected, so I just direct you to look at that. Thank you.
Thank you. And then Rita?
Hello, Rita. Is it on? Okay. Rita Hegren with AFT Utah. Speaking in support of draft 3. Some things I'd like to point out. I like the lines 297 to 299, where you have who's going to review the licenses would include actual licensed teachers. So I think that's a huge improvement. Moving to the LEA specific licenses, and this is where a lot of the majority of the change happened from draft 2 to draft 3. We really like all of those added in parts, as Sarah so eloquently described, because they require forethought and a desire to become a teacher. It's not just like, oh my gosh, we need somebody, let's get them. Okay? Someone can't decide the week before school starts that they want to be a teacher and they can go in and get one. By having to go through the modules and do some training, we're getting someone that's going to be more serious about becoming a teacher. But we still believe that a candidate for a license must have classroom time experience as a student teacher, as an observer, as an aide, because without that, it would be like, here's my analogy. I have a degree in biology, let's say. I want to become a doctor. I find a practice that will hire me and give me patients with me never having gone through any clinicals. Okay? That is the equivalent of not having any classroom experience. When the letter that we sent, we said a minimum of 5 days, and I'm thinking that's way minimum. But if we need to have someone at the beginning of the school year and they haven't and this is the argument, like what if they decide to do it over the summer? Well, I'm pretty sure you can get one of the administrators or another licensed teacher in to supervise that class, to start that class, as Tyler Howe did at Westlake Junior High, STEM school, while that candidate is learning some of the classroom situations and how to handle things. There are ways to do it. And I urge you to put that in. Thank you.
Thank you. Yes.
I liked your idea.
Oh, thank
when
you.
I got your email about,
Yes.
some sort of 5 days, and then I look at, where'd Cindy go? I don't know where she went. Anyhow, she gives the scenario that she's been trying to find.
She has a day job.
Oh, yeah. But she's talking about, and I think that Royce and Terry would tell you that there are people hired that first week, like Cindy just told us, that she went through applicant after applicant after applicant and finally got a science teacher. So my concern is how do we get that experience for those people at the last minute? I mean, I like your idea of having an administrator go in, but I'm not sure with all the 50 million other things an administrator can do so I'm back to square one, and that's a really troubling thing because I totally agree. Like if I decided to be a teacher and they needed somebody, I don't even know what I would be qualified in, like third grade nothing.
Third grade math. Third grade math, I'm sure you are.
We don't hire third grade nothing.
Like I don't even know. I have no ability to teach anything. I really don't think. But yeah, debate. A social work class. But you're right. I would have no ability. I would not even know where to start.
Right.
But I'm trying to figure out how we do this because hey Spencer, I think that that I don't know how we get that practice in. That's the
that's huge.
I think that's what we need to talk
here's
about.
the one idea. Another idea that if it can't be an administrator, there might be an instructional coach. And I think they are more prevalent in the elementary situation than they are in the secondary. My whole career has been secondary. So, but an instructional coach, maybe the district or the charter school board could have some available that could go out, things like that. I think there's ways to get it, but throwing someone in at the deep end when they don't even know how to turn on the computer and log on, let alone take roll and do any classroom management. They haven't, because what you have in the modules in theory is great, and I'm great at reading things and taking tests. I mean, I score great on tests, but doesn't mean I can actually apply it in the classroom. And being in there, we've got to find a way to get that in there. With instructional coaches, maybe there's some retired teachers that would be willing to come back for those 5 days, but not long term. There's all sorts of options. We have all sorts of resources to make this happen.
Okay, thank you.
Thank you.
Okay. We have 30 minutes to do 2 rules.
Are we going to go forward on the next one, or
No, we've got to hash out this one.
Okay.
So we can do a motion and then we can discuss it, or we can.
You know, I'd like to say a couple things because I agree. We have had this discussion for now. We started our task force 2 years ago, I think it was. So we've had this discussion, and Heidi Matthews one time said, I think we're still putting a Band-Aid on the issue, and I agree with that. I look at I read something recently that a lot of people are leaving the profession to stay home, and I just really think that we need to make this a profession where people can work and have kids, where right now we have so many people that leave because it's just so difficult to teach and have kids and have a family, and I think it just leads to another discussion. I believe the whole board, this is really I don't even know where to start, and so I would like to throw a motion out that we submit both of these to the full board. No?
I think we should do one or the other.
We have to make.
Or a combination, like we could adopt draft 2 and then
That's what I
amend
was
it.
going to do.
So if we adopt
Okay.
draft 2, make some amendments.
Okay, go ahead and do it.
Okay. And then I'm not sure how we want to do that because I don't know where to even start. I have to follow
Right.
through on draft 3.
Yeah.
So
Okay.
who?
So
Brittany.
I move that we adopt draft 2 on some reading. On first reading. And send it to the full board for approval on second and final reading.
Okay, so the motion before us is to adopt draft 2 on first reading and send to the board for approval on second and final reading. Okay, any discussion to that motion?
Yes.
And now we can make amendments.
So, these are the days when I hate computer copies and I need a paper copy. So, I don't know, I might be able to find where I am. So maybe, can we start on line 258, I think? Well, the numbering is going to be slightly different because this is draft.
Looking at draft 2.
Draft 2.
Yeah, it'll be a little bit different, but I see where you're.
So 258-ish. Maybe. So this was the recommendation of filling in a loophole, right? Is that right, Travis? So I don't know where those lines go, but completion of, so adding the completion of little I and little 2I.
So you would add B and then I and.
So amendment 2 on
Amendment 2.
the Lear and Cannon proposal.
Do you want to insert the whole amendment?
Yeah, I believe that's what they said, that it that there would fill a loophole, a teeny tiny loophole. Right? Yeah.
Yes.
For ease of use, the one that just has the amendments broken out, it says where on draft 2 they would go.
So that is.
Yeah,
So when it says after line 258, that is where in draft 2 it goes, just so you know.
Thank you. So I would like to amend that to accept amendment number 2. So after line 258, add completion of a bachelor's degree or higher from regionally accredited institution or skill certification to specific CT area, blah, blah, blah.
Okay, so we have an amendment. Let's just do one amendment at a time. So the motion is to amend draft 2 to insert Lear and Cannon Amendment 2. Any discussion to that? Okay, we'll vote. All in favor, say aye.
Aye.
Aye. Any opposed? Okay, motion passed unanimously. Any other amendments?
So then on line 297 to 299, in draft 2. So this is the superintendent shall designate a panel of at least 3 individuals, including at least 2 board licensed educators not employed by the board. So I move that we accept Amendment 3 on the Lear and Cannon proposal.
Okay. Yes.
And one thing that I noticed from the conversation, and I don't know if you'd be, I think that there's some clarification that could be made. If so, if we look on lines again, is it 297? So it is 287 through 290. Right on line 289 to insert or denial after approval, and then
So on 289
of draft 2, and then on lines 291 through 292. What I would recommend on 292 is after the word appeal, insert the words, and make a recommendation to the superintendent for the superintendent's review and decision as described in subsection 9.
Okay.
Like that? Okay.
That would be my motion.
I am not about to repeat that. So, yes. So the motion before us is to accept Amendment 3 with additional amendments.
Yeah, I got it. Yes.
And Angie will read it.
Yes. So this amendment that we're currently voting on would be to draft 2, and what you're voting on is to insert the words on 289 after the word approval, put in or denial, and then subsection 10 would now read, so this would be the new lines 291 and 292. The superintendent shall designate a panel of at least 3 individuals, including at least 2 board licensed educators not employed by the board, to review an appeal and to make a recommendation to the superintendent for the for the superintendent's review and decision described in subsection 9.
Okay. Okay, all in favor, say aye.
Aye.
Any opposed? Okay, motion passed unanimously. I think it's just you.
I don't want to Oh.
Yeah.
Okay. So, so 319 to 331, Amendment 4, I don't want to go exactly with Amendment 4. However, can I just say some thoughts really quick on this concept? So you've got an LEA, and we're requiring them to put a policy together. And in that policy, we require a few things. We require that the policy has educator preparation and support, which I'm not quite sure I understand all of a sudden. So is little I the only thing that's included on the that's required on the policy? So it's little I. Okay, so sorry.
There's I.
As established by the LEA. So you're requiring them to articulate the support that they're going to give to this candidate. Okay, it's going to be aligned to the educator teacher standards, and so could we require in this policy maybe just the LEA is going to somehow articulate, thank you, the LEA is somehow going to articulate why they're going this route. So it's the conversation that they're going to have between themselves and the candidate and say, why is it that we want to do this LEA specific route and not an associate license?
Travis?
So,
I think if that's the amendment you'd like to propose, I think your best option on line 320, where it talks about the criteria for employing teachers, there would likely be some language to change that to include what you described.
Okay.
That would be my recommendation.
And then my question would be, articulate it to who? Because my understanding is the LEA, the school has to go to their local board. So would they articulate this to the local board? And then would the local board articulate to us, or?
So, sorry, I'm trying to envision what this would look like. And so it's going to look a little bit different in every LEA. However, they're going to have some kind of an application process, right? They're going to have to communicate somehow to their board what they're doing, right? And so I'm guessing they're going to have it on a piece of paper or an email of some kind, right? So they're going to say, they're not just going to verbally be like, hey, can we hire this person?
Right.
I would assume, because if you have a policy, you have to show that you're following your policy. And so just in the policy saying, and maybe criteria for employment is sufficient, but just the concept that the LEA or the school, the hiring entity, whoever's doing the hiring, has to tell their board, this is why we want to do the LEA specific license. And so it doesn't have to be proving untenable, because then it does become subjective, like yes or no, but just to explain, here's why the LEA specific fits for this particular circumstance. And so would it be on, because that's little criteria for employment is under the effective teaching standards. Am I reading that correctly?
It's on 320.
So it's the 1I, 2I, 3I.
Mm-hmm.
So criteria for employing educators with an LEA specific license, including reasons why that. Sorry, my
I
verbiage
think that
is
would
bad.
be the good place to do it, don't you, Travis? We could just do right there at the end of line 320, including,
Yeah, I think that if you want the local board to make that decision, and if that's what you're trying to articulate, I believe it would be that the policy is the criteria for employing educators with an LEA specific license, which requires the hiring agent to demonstrate to the local board that things are unreasonable. I'm making stuff up as I go.
And I don't want, so am I. but I don't want it to be unreasonable and technical, because that verbiage automatically puts in that subjective piece where you're saying somebody is and somebody isn't, right? Yeah. And it puts in that line, but just the fact that I am explaining this to myself even. I'm telling you why why we're choosing this licensing area and not the associate license.
And they would be telling their local board. And if because their recommendation is going to have to come to the superintendent. Right. And so how do they recommend it? Well, here's why we recommend this. And so it's just, I'm really sorry that I don't have the wording right.
It's new.
And so
it's a new thing. Yes, Travis.
Can we propose that Angie and I work with Brittany for an amendment that could be brought to the full board next month on this area?
And so if anybody else has any thoughts,
I do have a thought on this one.
Incorporate it into draft 4, though. We could actually work on something and get it into draft 4.
Yes, I mean, you could, that would
be
too.
That would be.
I'm not sure that I have an answer, though, Brittany, but I'm trying to get clarity on this. So taking the idea or the concept that the LEA is talking to their board, and so now we're going to require that LEA does something before they ask their board for that.
Right, I'm assuming, right, and anyone who hires people can correct me if I'm wrong, you have an applicant or you have a principal who's looking to fill a spot, right? You have an HR department and you're saying, here we have a candidate, and you assess that candidate. Are you going to go in the associate route because you fit that well? Or no, this is going to be better and this is why, right? And so I want that decision process to be articulated. Why is the LEA specific license the right way to go with this particular candidate? And so the board of that LEA does not hire anyone, right?
Right.
And so that hiring entity, either the principal or the HR department, whatever it works in that LEA, is going to have to communicate to their board for approval why we're going this route. And so in that process, they need to articulate the decision that was made, why LEA specific is the way we're going with this particular candidate. Because I don't want them to demonstrate that it was difficult because that put subjectivity into it, but why was this decision made at this point? And then the board would approve it, or whatever they want.
Their local board would approve it, yes.
I have an idea.
They'd send it to the superintendent.
But the LEA, the governing board.
So I apologize, you're going to have to go to draft 2 because I was trying to find something in the rule I thought was there, and I couldn't find it. Now I found it because it's a little lower. This is line 345, 346. Where it says approval of the request by the LEA governing board in a public meeting no more than 60 days prior to the application. And then simply add, which includes LEA review of the reasons for the license or the rationale. That's rationale. That wasn't my idea. That was Carol's idea. That was.
Don't say that.
No, it was. That's a good idea. I didn't want to take credit for it.
No, it's a good place.
Poisoned the idea.
No, it's a good place to put it. It's a good place to put it.
Which includes the
The rationale
Yeah.
for the request.
Yeah, I like that. So that's line 3.
So is
We just
that,
need enough time.
Okay, but now we know what
so
it
is
is.
that your amendment?
Yes.
Okay, we're gonna have to read that back. Okay, so, yes, the amendment before us is,
To, at the end of line 346, after application, it would state, comma, which includes the LEA's rationale for the request.
okay. Any discussion to that? Okay, seeing none, let's vote. All in favor say aye.
Aye.
Any opposed? Okay, motion passed unanimously.
Um,
And then, yes, Board Member Belknap?
Yeah, this is an easy one. I would just like to make the amendment that we include candidate
In
as the
place of
term.
individual.
Yeah, I really appreciate it.
Okay.
So, do we need
It's
to have?
several locations.
It's several
LEA
locations.
So
specific.
throughout,
Yeah, is that
Okay.
okay?
Yes.
All right.
so do we need a vote on that?
Probably.
All in favor? Aye.
I just wanted to get that done.
Motion passed unanimously.
Brittany, you can keep going.
Okay. Yes.
Something easy, I think, is Amendment 9, where they want to not create a mentoring situation forever,
Right.
which is 377, 382.
It's actually 350, 355 of draft 2.
Oh, 350 to 355 draft. Thank you. It makes a lot more sense.
Okay, and if I understand the intent of that correctly, it was that, so you provide a mentoring program, you're going to provide that mentoring program the whole time your person is in the associate bucket, right? And so you wouldn't have to put a time on it. So it's just when you're, if I read it correctly, an LEA shall provide a mentoring program that provides trained mentoring and annual mentoring for anyone in an associate license, right? And so the only limit of time that we need to do is somebody in the LEA specific, which would say an LEA specific educator license. So I don't know if we want to add something there.
Yes,
May I make a suggestion? I think the problem comes from the combination of associate and LEA specific in A.
I think so.
So simply making a C so that it says any educator holding an associate educator license, colon, any educator holding a professional educator license, colon, and any educator at least 2 years for an educator holding an LEA specific. You just break it out into its own
Okay.
thing.
And I'm just going to make it B and put professional last.
That's fine too.
See if that's okay.
Doesn't bother me.
So,
Yes.
so
Hopefully Angie's writing all this
I
down.
am.
okay.
Do you want me to read it out to you the way it's?
Yes, please.
Okay.
Don't forget to turn on your mic.
All right. So now in draft 2, lines 350 through 355, we'll have A, and I'm just going to take out the word any because I hate the word any. So A, educators holding an associate educator license, semicolon. B, for at least 2 years for LEA-specific educator license holders, semicolon. And C, educators holding a professional educator license, etc.
With less.
Okay. So that would be the amendment.
Okay, so that's the amendment before us. Any discussion to that amendment? Okay, seeing none, we'll vote. All in favor, say aye.
Aye.
Any opposed? Okay, motion passed unanimously. Yes, Board Member Belknap?
Brittany, I'm going to go in here. I have some questions on the Amendment 8.
Okay.
Where they've changed it to a 2-year. You know what? I'm really having trouble toggling between draft 2 and 3 at this point.
It's on 332 and 333.
Thank you.
Draft
332 and 333. And at least I actually really like that we give the opportunity to a district to decide if it's 1, 2, or 3 years. But then my sidebar question, my squirrel question is, what if they want to continue with an LEA specific and the entire time? And I just have to go back to the dance person. She wants to teach for 6 years, and that's what she wants to do. Have we handcuffed her anywhere here?
Have we, Travis?
So the next line, it does require that the first time that you want to renew that type of license, the state board has to prove it in the same way that the local board did. But beyond that, no, they could then continue to renew it using the standard renewal rules that we haven't written yet.
Okay, so just repeat this. The first time they do it, it literally goes through the local board, and for the LEA specific, goes through the local board to us, right?
Yes.
With what we just did. Then the second time, if they want to do another 1, 2, or 3 years, then they have to come, and it comes to the board here.
Correct.
And then if they want to do another 3 years, then it goes through the original renewal process?
It would
or?
basically, I don't know the answer to that
No, look
question.
on line 336, draft 2. Sorry to interrupt, but it says
Oh,
that subsequent renewals might be approved by the board on a case.
Oh, okay.
On case by case.
So you could
Right,
require
case by
them
case
to keep
basis.
coming back to the state, or you could say, okay, you can
Either
just
one.
go stand.
Okay, all right, thank
Okay.
you. Thank you.
So did you want to make any changes to that, or are you good? Okay. Good.
Yeah, go for it.
I just wanted to at least bring up something and maybe make a motion on their Amendment 5. And I understand, I can't remember who said something about it may be difficult for them to complete some professional learning modules if they're being hired at the last minute. I do know that to be a sub, because I took Connie Morgan's challenge and I started the process to go substitute, you have to go through a training before you can substitute. I did not know that. Apparently, I have to go through the training. I'm not going to sub, by the way. I just am going to go sit in somebody's class. But anyhow, is there something in there that, or should we just leave it up to the LEA to make that decision? But should they have some sort of understanding of, I mean, I understand where they're saying. Are we opening ourselves up or the schools up to lawsuit if they don't have a special education understanding? Because the little training I have to go through to be a sub at Cache County, I have to have.
What line is this?
It's her amendment, their Amendment 5.
It's line 324.
So I know that I have
found
to
it
have
line 22.
educator ethics and a little bit of classroom management. I think it's 10 hours.
Yeah, it
No,
is.
it's, I don't see, not for LEA specific.
This part.
They may
is
not
this.
request an LA specific for special education or preschool education.
No, but they're saying you have to have a basics, but like this little 10-hour training I have to have has a couple things like this. So should we have something in there, or should we, should anybody walking into a classroom, like if I have to do it as a substitute, should we expect somebody to do those 3 things?
I just got it 2 years. Brittany, do you have a comment?
Did you have?
So my question is the timing of it. Like obviously there's going to need to be some training on educator ethics, because even if they're in a classroom and they don't know that, you can't spank kids anymore, right? You know, the obvious things or whatever. Those are things that need to be trained of anybody that's in a classroom. And so I don't mind, as we talk about this concept, that LEAs, we point out the obvious to LEAs that they need to be trained on some of these basic things. My question, though, is these modules, we keep talking about them and we don't know what they're going to look like, you know, their size or their scope, and some people want them to be very intensive, and some, you know, we keep talking about them and we don't know what they are. And so if we decide to go this route and put this somewhere in the LEA specific, then we have to think very carefully about the timing and the requirement timing. So is it, can they apply for it and then make sure that training is occurring within the first so many days of employment or whatever? But
one of the things that Angie wrote was within the first year of employment completes, or we could even shorten that to 6 months or 3 months.
Because the substitute training probably doesn't take more than a few
10
hours. Okay.
I think it's 10 hours, they said. It's online.
Yes, Travis.
One of the things I wanted to bring to the board's attention is that under the current system, it does not matter whether or not you have a educator license to the LEA until November 15th. It makes absolutely no difference until November 15th. That's the first time funding is pulled based on licensing.
So they can hire you and you can receive your license within that first.
That's why, quite frankly, we don't bring any letters of authorization to the board until the October meeting.
Okay.
To give them time to get things in order.
And so,
sorry. So could I?
So it could do a time.
I'd like to make a motion, although I just
amendment.
Motion to add that they have an educator ethics, classroom management and instruction, and basic special education law and instruction.
No.
No, it's not for LEAs.
It's in for associate. She wants to do it for LEA specific.
Should they do? Yes.
Okay, so my thoughts is that because these are specific modules that are identified elsewhere and have definitions and are associated with the superintendent, et cetera, I don't want to use the same wording for that, right? And that's my thought, just my opinion.
So this would be a separate...
but just putting into that process that an LEA needs to ensure, you know, training on, right? And so that they're not required for these same modules that have all this other baggage tied to them with the others, but that they ensure training on certain ways. And so then the LEA would, I mean, these are obvious things. Someone's not going to put someone in a classroom and not train them on basic ethics.
Well, okay, I'm going to withdraw that idea, and I'm going to kind of play with it and send something to Travis about it.
Okay.
I figured out what I wanted to say.
Yes.
Sorry. I like the idea of moving on Brittany's idea that the LEA is going to ensure that A, B, and C are done.
And but it wouldn't be the modules made by the superintendent. That's what we're striking out. They would be their own thing.
Let's put it in.
I like that.
Let's get it done.
One of the ways to do that would be to use the language from Amendment Number 5, but simply change learning modules established by the LEA rather than established by the superintendent.
And I don't...
Okay.
Or not modules. Yeah.
I think Angie has something.
So what you could do is put in a new D that says within the, and you guys can choose the time period. I have first year, but it could be 60 days or 30 days, you know, of employment, whatever you want to say. Within the blank time of employment, the LEA trains the candidate on, educator ethics, classroom management, basic special ed instruction, and the Utah Effective Teaching Standards.
Will you read it one more time, Andy?
Yeah. So it would be a new subsection, I guess it would be new subsection C in draft 2, right?
No,
starting on what line?
It would be a D.
Would it be a D?
324.
Okay.
Okay.
So it'd be D.
So yeah, right after 323. So it'd be a new D. So D, within the blank, whatever time you choose of employment, comma, the LEA trains the candidate on, educator ethics, classroom management instruction, basic special ed law and instruction, and the Utah Effective Teaching Standards described in R277530.
So time frame, 60 days, 90 days? Yes.
The thing is, there's some of these things they probably need immediately in 5 days. However, they are maybe not going to understand, thank you for these papers, oh, she's gone, that the entire teaching ethics, it may take a year for them to get all of those. And so if putting a time frame, I'm not sure where to pick there.
Maybe within the first year? Yes.
But there's a certain amount of liability on an employer, right? And so they know, if we all know that if a principal has an employer and they are not acting within the law, right, that they are liable for some of those actions. And so I think it's important to recognize that an LEA is going to say, I need to make sure that this employee knows that you can't break the law. You cannot do this in a classroom. And so I think it's allowing the LEAs to prioritize that effort and those things that are there. So I would say within the first 3 months or even the first year, because you talk about the Utah Effective Teaching Standards, that's something that's demonstrated over time. And so I would say a year is fine, but leaving that liability and that responsibility on that employer to recognize that I'm not going to wait until day 364 to talk about ethics in a classroom, right? And so it's giving them the flexibility.
I like that within the first year. Are we good with adding that time frame within the first year? Within the first
year of employment.
Year of employment. Yeah.
But there are some things I just really feel like somebody needs to know before they step in front of a classroom. But on the other hand, I do trust LEAs. I mean, this is an LEA specific license.
Right.
I'm struggling with that because I believe that, but I look at the principals that I deal with and I just can't imagine them not doing something on an LEA specific.
Yes, remember.
One of the things I don't think we talk about very often with these LEA specific and the associate degree is it is a great responsibility that LEAs take upon themselves to go this route, right? It's not a free ride. It's not an easy route. It is a huge responsibility that the LEAs take when they make the decision to accept a candidate in these routes. And I think they recognize that because it's on them now. They don't get the luxury of saying, here's somebody that's come prepared and my responsibility isn't as great. And so they take that and I think they recognize it. And so it's recognizing that they know that and they are going to take responsibility for these educators that they are deciding to hire.
Yeah.
And I think they do.
I think they do too. Okay. So is that your amendment? And within the first year? Just to put the, okay. So let's read it and then we can vote on it.
So, I'm sorry. Who made the motion?
Brittany did actually, and I just.
Support member Brittany Cummins' motion is after line 323 to insert the following. Subsection D, within the first year of employment, comma, the LEA trains the candidate on, I, educator ethics, 2i, classroom management and instruction, 3i, basic special education law and instruction, and 4, little I, little v, the Utah Effective Teaching Standards described in R277530.
Okay, so that's the motion before us. Any other discussion to the motion? Okay, all in favor say aye. Aye. Any opposed? Okay, that passed unanimously. Any other amendment? No. Any other amendments, or we? Yeah. Okay, so we're going to stop now. Do we have any other amendments for 301? Or are we ready to vote on it and send it? Are we ready? Okay. So, this will be a draft 4 though, right?
Draft 2 as amended.
Okay. So the committee recommends of sending draft 2 as amended on first reading to be adopted by the full board on second and final reading. Any discussion? Yes.
Do we want to say second and final reading, or, because I'm thinking this is going to be quite a discussion.
It'll
I'm
be a
wondering-
discussion, but
But that would be the motion.
Okay.
yes, they can.
If you don't mind, I'll just give you a reason why you may want to do it on second and final. We are way behind where we were going to be, where we're supposed to be at this point, because this rule is kind of the foundation for the other 20 to 30 rules that we still have to get updated before January 1 of 2020. And you will have another public comment period after it is filed. So if right now at this point, if you do it on second and final in October, it'll be open for all of November for public comment, and it'll take effect in December. If you wait and don't do it on final reading again, then now you're starting into January, which gives you 12 months to get all of the other rules. So it's just something to consider. We are pretty behind on time, but that's it.
I have another question. Chair, you used the term "send up" to be adopted by the board. I'm not sure that's the right. What? Approved. Thank you. So I thank you. I'm sorry.
Any further discussion to the motion? Okay, all in favor say aye. Aye. Any opposed? Okay. Okay, we're hoping to come back to 303. Yes, Tracy?
Can I just make a quick comment? It wasn't relevant before you passed the rule, but something I think that you need to consider going forward.
Okay, if you can come to the mic. Sorry.
It's not, Tracy Watson, UEA.
I'll allow. Go for it.
Just a comment for you to consider. When you have a year for this person to learn the educator standards and the ethics, if there's an allegation of professional misconduct, how will that be treated? And that's just something to consider, because a lot of times when you have those allegations of professional misconduct, it's the first time an educator is actually looking at the educator standards. I mean, everybody says that they read them and everything, but there isn't really, I mean, they sign something that says that they read them, but there isn't a lot of training on that. And so I just think there's a lot of burden. I hear what you're saying. I heard the debate. I didn't think it was important to say to stop the rule, but I think it's something I need you to consider, because it's going to happen.
Can I ask a question?
Yes,
a
Board
legal
Member
question?
Brittany Cummings.
So I'm guessing somebody who's hired realizes that they are obligated to all the board rules that are in effect, and so I think it would be very relevant or important for an LEA to let a candidate know, somebody they're hiring, and saying you are obligated under all these things, whether you know it or not. Right now, you are obligated, and so if you have any conduct outside of those educator standards, then you can be, you lose your license, prosecuted, whatever the extent of the misconduct is, you're obligated for it. And so if I was that person, I would read the rules and I would figure it out and I would make sure that that happened. But the LEA is going to ensure that this takes place with a certain time period. And so I'm just saying that they need to know that they are legally bound by anything that they're agreeing by accepting a position as employment. And I'm guessing, is that, am I out of bounds in that assumption?
She's right. Okay. Okay, so we're going to move on to 2.3, and we'll hopefully return back to 2.2 after. So 2.3, charter school expansion requests. And
background around before.
Yeah.
So the State Charter School Board, and we've got Jennifer Lambert and Rebecca Cisneros here, who can come up and talk to these expansion requests, and they were both approved by the State Charter School Board, I believe unanimously on both of them. And you can see the reports the State Charter School Board staff prepared are attached in board docs. And so now this is coming to you for your approval of their approval for the expansion requests.
Okay. So who? Yes.
I have a question. These aren't any, there's no waiving of the rule because it's a year from now? I don't know, because I don't really have any other questions than that.
So Jennifer Lambert, Executive Director for the State Charter School Board. These do not need a waiver because they are within the time frame in the board rule.
Okay.
Okay.
I'd like to make a motion.
Okay.
That we accept these, both of these, the Reagan Academy and the Excelsior Academy, increase in their total number of students.
Okay. So the motion before us is to accept Reagan and Excelsior, their expansion requests. Any discussion to that motion? Okay. All in favor?
Aye.
Aye. Any opposed? Okay. Motion passed unanimously.
Thank you.
Oh, okay. Item 2.4. Oh, we might need to skip that one.
And actually Ben's not here, and actually all three of these are Whitney.
So we can go back.
If you'd like, we all of a sudden moved. Do you want to go back to
We could. Can we do that one?
The problem is that she's not here either.
Oh, okay.
So let me, do you want to take a tiny break?
Should we do 2.9?
They're not here either.
Okay,
So
then let's go back. Let's go back to
So
2.2 then. I'd
we
rather.
can do 2.2. That's one I can do and Travis can do. And
Yeah.
then we'll start texting people to get them here. So
Okay, so let's move to 2.2 and let's go ahead and hopefully we can get that one done.
Do you want me to give a summary of where
Yes.
we're at? Okay. Just as a reminder, 303 also was approved by Law and Licensing in June. Travis, correct me if I'm wrong. And as part of your discussion, you approved the draft and you wanted us to prepare a couple of options for the definition of educator prep program, which is a key term that's also referenced, you'll remember, in 301. So this was all very related. And so in lieu of talking about those two definitions, which I've got them projected up there right now, a couple of options for the definition of in 303 of educator preparation program, it seemed like at the time Law and Licensing Committee felt comfortable with 303. They just wanted to work on this definition. So I think today we could talk about the definition of educator preparation program, and then of course any other amendments that you'd like to make to 303. So that's where we're at. It's 303 draft 1. And may I make a comment?
Yes.
Legally, there's no difference between option 1 and option 2. So the difference is in how the emphasis is there. It includes, the educator prep program may include a program developed by or associated with an institution of higher education, an LEA, or the board. But legally, really, they're saying the same thing. There's just, I think, a preference on what you would like.
Okay, Board Member Brittany Cummins.
So this is related to a question that I had on line 107, where of draft 1, where it talks about the board shall do something and maintain. And maybe we talked about this already, I'm sorry, but so is this the intent that the board could actually have its own educator prep program?
Well, it says the superintendent. So shall design or maintain. So is that what, yes, Travis?
the intent of the language, as we wrote it, was intended to say districts and charters have let us know that it's not ARL that they don't like, it's the restrictions. That there's value in having a model program that they can simply use rather than creating one their own from scratch. So this rule is saying, just like an evaluation. So in evaluation, you require all districts to have an evaluation tool that meets certain standards, and then the superintendent creates a model that they can adopt if they choose, or they can do their own. And that this is suggesting the same thing, that our ARL would go from, rather than us dealing with individuals, we would deal with LEA saying, here's a model program, Tintic, that you can use if you'd like, or whatever else you want to do.
Can I ask a follow-up then? Thank you. So what does that model look like currently, the ARL? Can I take a class, an online class through the Utah State Board of Education to get credit? Or are you, in your model, do you just point me to UVU, USU?
I think it's both.
Okay.
Because one of the things to remember is ARL was created in a time when universities didn't want anything to do with it, and so we had to create all those things on our own, and the ones that chose to do that were Salt Lake Community College, and that's why ARL looks the way it does now. But as we've expanded and tried to reach, what we've started doing is reaching out to universities, and they've responded by providing things. So for example, the elementary methods classes that ARL does are actually through the University of Utah. We have a partnership with them that they offer those in the summer for the ARLs to give them that. We've been having real trouble with special ed in ARL, and now we're partnering with SUU to provide online classes. So we would much prefer that universities design the classes and we just point people to them. But when nothing is available, that's when we feel we have to create something. So I think would be both.
Okay, thank you.
Okay, we'll go ahead and listen to public comment on this. Sarah Jones and then Rita Hagren. And we're going to do 2 minutes. Do you have your...
Yes. Well, I will do my best in 2 minutes.
Sorry.
Sarah Jones with UEA. We do have some concerns about the idea of defining educator preparation program. So my comments will relate to that. We really feel like the definition needs to distinguish between a university-based program and an alternative program, whether that's LEA-based or whatever that might be in the future. And the definitions as they're currently constructed really equate the two routes, even though we say that they are not equivalent. Let me give you a couple of examples. On line 60, it says, in addition to the requirements, an educator preparation program that is not also a Utah LEA. So it says that essentially there's a standard for university-based programs, and if you are not a university-based program, these standards will not apply to you. And that includes some language about what happens if you're an online university. But we also have online charter schools, for example. So the idea about the online instruction, that only applies to the university program. Only the universities have to establish entry requirements designed to ensure high-quality individuals enter their program. Only the universities have to have a student teaching experience. Only the universities have to have the pedagogical performance assessment. So right now, when you have the definitions, option 1 or option 2, as they currently read, it just throws any preparation route together, even though there's 2 different standards in the rule right now for what they have to complete. Second concern about equating these two is on the definition in lines 14 and 15. So in defining an LEA, it includes an LEA as an accredited private school. So it's not just a charter school or a district school, but also a private school. But if you think about the board's ability to have oversight over a private school, you really don't have any oversight of a private school. So you could have a LEA-based preparation program that's at a private school, and what kind of oversight do you have? So is that actually equivalent to a University of Utah or a preparation program? The third thing I'll just point out is that a USBE approved LEA-based preparation program for state license is really we would call it a significant shift in practice. It's going to be different than an ARL, I would say, different than the APT. And that idea, that kind of big picture philosophical idea, it's this idea of, again, in line 60, where you can have an LEA. I mean, it's not explicitly called an LEA-based program anywhere in the rule. It's implied. But this implication that you can have an LEA-based board-approved program is a pretty significant obligation on an LEA, I would argue. And while an LEA may choose to do that or choose not to do that, is that a good diversion of resources to have LEAs when we're already struggling with funding to be preparing teachers at that level? So I just think that's an idea. It's a philosophical idea that really needs to be debated, I think, by the board, of how you feel about this idea of the LEA based. We're not necessarily opposed to that, but there are some concerns that really haven't been talked about, I think. And then the fourth thing I'll point out on this idea of the definition and the why we say there needs to be a definition for a university prep program and anything else is this idea of professionalism. So if you are in some kind of non-university based preparation program, it implies that you are employed and teaching while you're going through the preparation process. And that means you're learning on the job. And that's really not the best practice. It happens from time to time. We do have those alternative routes, but it's not the best practice, and it's not the same thing as university preparation. We know that research shows comprehensive, rigorous university preparation has higher retention rates for teachers, higher student success. And so we think that the definitions and what you really intend to do with with preparation should clearly delineate. There is a university preparation program that goes through this approval, and then you have an alternative. And the alternative should be defined however you decide to define that. But it shouldn't just all be lumped together, because for the reasons I laid out, they're really not the same process.
Okay, thank you. And then Rita? Do I? Yeah. You're Marilee, right?
Hi, Rita Hegren. Hi to you. I'm Rita Hegren with AFT Utah. I'm only going to take about a minute because I'll have ceded some of my time to Sarah because she's pretty eloquent, and so you're welcome. So research-based and all of that. We completely agree that they need to separate the definitions of the educator preparation program. The university-based one is designed for teachers to come out with a professional license. All other pathways are for an associate license, and that should be specified. And this preparation is for an associate license, this preparation is for a professional license, and all of the standards should be and all the requirements for those programs should be based on those outcomes. Thank you.
Okay, thank you. And then Marilee. And if we can.
I'm Marilee Coles-Ritchie, speaking for myself, and I think that I mentioned this before, that the associate license and the professional license need to be indicated somewhere so parents are aware who their children get, and so that it's very clear that if there's patterns as far as equity is going, and in what schools there's more associate and what schools are more professional, it's really important. Again, it needs to be an exception. The associate licensure route needs to be an exception, not, this is something of the norm. And I'm afraid that that is not clearly defined. There needs to be some steps put in place where it's really clear that the associate's license is not the preferred route to go. It should be exception. Now, I know personally that there is a candidate who wanted to go on the professional route but decided that was too expensive and too much time, so they decided they'd go the ARL route. This is not a rural district. This is here in Salt Lake City, in the greater Salt Lake City area. This person was hired at a school to teach AP English and 11th and 12th grade English. This person was hired in June, not a week before school started, right? They had 2 or 3 more months to possibly look for a professionally university-based teacher candidate. But instead they chose this person who is going to go the ARL route, and it was not an exception. This is something in the grade. So they had time to try to find someone in that, and they didn't. There's a lot of talk here that, oh yes, of course we want the person from the university preparation program, but there's not anything in place to really indicate, do those parents know that their kids are with this teacher that's learning on the job, and that it was in a greater Salt Lake area, and that they might have had more time to find somebody who was better prepared? No. And this is a person I like who decided this route. But I'm saying, so why wouldn't a candidate just say, well, I've heard from this person they did it, this person they did it. Why would I choose to pay money and time to go for a university preparation program? Because sometimes people don't know what they don't know until they're right there in the job. And I have a feeling this person's not going to last. Retention is gone, and then they've lost that time. So I think there's a lot of things to take into consideration here that are not clearly indicated as far as that this is an exception, not the path that is going to really fulfill the 10 standards that everyone on this board said that we want to have teachers have. There's no indication that they know all of those. So
Thank you.
That's my comment.
Okay. Any? Guess I'm seeking for a motion or further discussion.
Okay.
So we can move.
So I move that we approve our 277303 draft 1 on first reading and recommend it to the board for approval on second and final reading.
Okay, so the motion before us is to accept R277-303 on first reading and recommend it to the board for second and final reading. Okay, any discussion to that? We do need to choose a definition at least, option 1 or 2,
So
and then we can move from there. Yeah.
Can I ask a philosophical question?
Mm-hmm.
So this concept of defining educator preparation program is new and kind of intriguing and interesting, and I think it comes with a lot of fear and uncertainty because it's stepping into something that I don't think anyone has ever looked at before as we look at what does it mean to prepare a teacher for a professional license, right? And all of these, that's their intent, is to prepare a teacher for a professional license. They just look differently. The experience is at a different time, right? Student teachers are in classrooms before they have a professional license, and they're in classrooms and they're doing those things. And so it's kind of interesting to consider. And so I'm wondering what are the benefits to delineating it? What do we gain if we were to pull those two things out again and draw clear lines around them that aren't already there as we go through the rule and define it? Anyone?
Board Member Belknap?
I don't have an answer for you, Brittany, but I think option 2 denotes that there are 3 different options. That there's the higher ed route, there's individuals with the LEA, and then there are board items. And so I actually like option number 2 because it doesn't delineate with definition,
but it
recognizes that they're very different programs.
Yes.
One thing that I'll just throw out as an option based on some of the comment that I heard that you could do, you could say educator preparation program means a comprehensive program administered by an entity that's intended to prepare individuals to meet the requirements of a professional license or license area concentration. And you could say, you could differentiate that for purposes of the professional license, for a candidate who wants to go directly to a professional license, it could be the university-based. But then somebody who's going from an LE, no? An associate to.
No one goes to it.
Yeah.
No one goes straight.
Can you come to the mic? Sorry.
Oh, because the student teachers are associate.
Exactly.
Have associates too. Okay.
If you're in a program, as soon as you've
never
met
mind.
the requirements for an associate, you get an associate, and then by the time you enter your program, you've completed the requirements for a professional.
Oh, do you want?
So I move that we adopt option 2 as the definition for an educator preparation program.
Okay. Any discussion to that? Okay, seeing none, we'll vote. All in favor say aye. Aye. Any opposed? Okay, motion passed unanimously. And then Board Member Belknap, did you have
Yes. I really appreciated Sarah's comment about now I got to find it, about the private schools.
Mine's 14 and 15.
Yeah,
Thank you.
we need to strike that.
So LEA includes, for purposes of this rule, the Utah School for the Deaf and Blind. Why do we have to say that? Aren't
We have
they
to say it in every rule.
Because they're ours. Okay.
Well, no, it has something to do with the definition.
But the accredited private schools, we don't have.
The
USBE.
Okay, so we just put a
Just
period
end it.
after that.
After
So strike out and an accredited private school.
And the only reason I actually appreciate this is because they're not LEAs in our system, and just for clarity, we're talking about K-12 schools here, right? We're not talking about colleges.
Right.
Yeah.
What is, okay, give me the reason.
What was it, Travis?
You are welcome to do it. No. You're welcome to do how you want. The reason it's in there is because if it is not, then RTCs, private schools that wish to help people have an alternative path to licensing will have no option. Their only option will be to use a university-based program because they would not fall into the definition of this.
But I thought this wasn't governing. I thought this was just for K through 12, not.
Correct. So this is Judge Memorial. So Judge Memorial currently uses ARL. They can't use APT because the APT rule excludes private schools. So Judge Memorial uses ARL when they want a licensed teacher. Now, if they don't want a licensed teacher, they don't have to do anything. It's only if they want to have their own program. That's why we wrote it in.
Okay, I see.
So I have a thought and a question. And my thought, similar to what Angie was saying, is that we just we don't have to define it as an LEA. We could maybe just add another definition that says for this something or other, because then I think it adds confusion when we try and define it as an LEA. It mentally jumps into a place.
I might have to reword some things, but yeah,
And
we could
so
do that.
so that would be my only suggestion. But then it goes, I think this rule, I think there was the concern that somehow we have oversight over private schools. We do not. However, we do have oversight over licensing, right? And so that's what this rule does, is it's our oversight over the licensing process that institution is taking, not that institution and its other functions. Because it's similar, like we don't have jurisdiction over higher ed, but we can still make rules in regarding to the licensing ability of those institutions. So
Okay, I do struggle with this, however, because we might give them their license, but they do not have to follow the Utah Effective Teachers standards. They do not have to do any of these things we require them, because they do not have to follow board rule.
But if they want a license.
Program they do.
To be an approved program for what?
Licensing.
For that teacher too. You have, but we don't get to walk into that school. We don't get to. We have no direction to them.
But we go and say, if this is what you're doing for a teacher, that's not good enough. That doesn't meet the rules, so you can't do that.
And I would probably throw on the table when it was the first, last, or any time that we've ever done that. So.
Yes, Angie.
Just as a reminder, so you're right. private schools don't have to have licensed
Right.
educators. However, if they want to be accredited, oftentimes they have to demonstrate they have at least so many licensed educators. So for purposes of being accredited and for their standing and recognition, they want licensed educators, and we're the only licensing entity in the state. So if we don't facilitate or allow private schools or somehow support this, we could see a new licensing entity being created outside of the board, meaning like a DOPL or something. So it is a weird issue, but it is a place where oftentimes there's a number of private schools that don't care, and maybe none of their educators are licensed, and that's fine. But there are some schools that they like to be able to demonstrate and show that they have Utah licensed educators, and that's where they have to follow the standards that the board establishes. Is that helpful or not really?
So then if we don't have that in there, then an accredited private school would not be able to come to us and to do.
So there, under this rule, there is no ARL. There is a model program that the board allows LEAs to adopt. Now, if you wanted to take it out of the definition of LEA and say put it on 110 where it says, the model can be adopted by LEAs or accredited private schools.
Maybe that would be
you
a better
could do it
place.
that way, and then it's not in the definition, and they can that way they can't create their own, but they can adopt the model that the state board has created.
That might be a better place for it. So moved. Okay.
Can you tell me where that is?
Line 110.
110. So
An extension of 107, so 107 to 1.
so we would strike it from
Strike it from the definition.
and add it to line 110. Yes, let's read that amendment.
So the motion would be to delete on line 15 and an accredited private school. And then on line 110, rewrite it to state may be adopted by an LEA or an accredited private school, semicolon.
Yes, board member. Bell?
Sorry, so it requires them to adopt what we've,
If they want,
if
may.
they want to.
May. Okay. Board member Brittany Cummins, or? Oh, okay. So any discussion to that amendment? Okay, all in favor say aye. Aye. Any opposed? Okay, motion passed unanimously.
I can't find it, but when Sarah Jones was up here, she talked about online instruction and that there was some differentiation between requirements. What line was that?
What line was that?
Okay.
5960.
Okay.
Oh, online. Oh, yes. I can speak to that, Chair, if you'd like.
Yes.
So the language there was actually intended originally to ensure that WGU, which is a Utah-based online program, would be something that we would use our resources to review and approve. But say Capella University, which is based outside of the state of Utah, that they couldn't just say, oh, we want to have a Utah-approved program. Then all the online programs start to come and request those, and we just didn't have the resources. So that's why that language, because this language right here, 61 to 63 or 61 to 65, is actually in the current board rule 502. That exact language.
Oh. Board member Belknap.
So just help me. Let's say the University of Phoenix had an online, and they have a physical building here. They could be an approved
Correct.
provider.
So for a while, University of Phoenix and Argosy University both
Did have.
had physical locations in our state where they operated, and they were programs that we reviewed and worked with. They've actually both closed down those campuses recently, so they won't be on our list anymore. But
So,
yes.
So it's not just limited to one. It's for anyone who
wants. Correct. So,
Okay.
Yes.
I actually appreciate that. So.
Yes, board member Brittany
Okay,
Cummins.
so then jumping to what Sarah pointed out, so let's say Utah Online was a separate LEA, and they want to create a program for teachers. this wouldn't necessarily apply to them because they're still under all the obligations of creating something under the LEA definitions? Or is there a loophole there that we're missing?
I don't think so, because it does say on line 60, a program that is not also a Utah LEA. So anything other than, like, if you're talking about online charter schools, only the Utah charter schools would be exempt from this.
So Utah Online is a Utah charter school.
So they could do a program or adopt our model or anything.
But they aren't exempt from, so they would just be doing something similar. They would have an associate teacher who would follow under all of those other obligations. They would have to have, the same experience that they're having. And so there's no loophole that's here that would have an online charter that would be.
You're correct.
Fine. Okay.
Or an online public.
Correct.
Our traditional district, sorry.
Yes.
But that would go through an LEA, which is a traditional LEA, so it would just be hired similarly.
Okay.
But this is talking about universities.
Correct. So it doesn't apply to any LEAs.
So any other amendments to this rule? Yes.
I just want to make sure, okay, because if they're not also a Utah LEA, so for example, Provo is part of Provo School District. They are not an LEA, they are a school, but do they fall under that umbrella then?
So Provo eSchool by itself couldn't create its own program, but Provo School District that would, and then Provo eSchool could use that program.
Okay.
Okay, if there's no other amendments, then the motion is to approve draft 1 as amendment and on first reading and recommend to the board to approve on second and final reading. Any discussion to that motion? All in favor say aye. Aye. Any opposed? Okay, motion passed unanimously. All right, item 2.4, so we've got Whitney Phillips, and this is the Board Policy 306, USBE Data Governance Plan.
Well, Whitney and David are coming up. Can I just say something?
Yes.
Okay, just to describe the differences in the two documents that are on board docs. One is the tract. It's probably the document that's easier for you to see the different changes in the policy from the last time it was adopted. But then the one that stated Board Policy 3006, September 2018, is what it will look like. And that's because the formatting and structure was a little off from what our normal structure is. But as far as following the changes that are being proposed, I would recommend you look at the tract amendments document. And that helps. And then I think Whitney would you like her to go ahead and
Yes, go ahead and start, Whitney.
The last time that you approved the governance plan was I think it was in February, and the first time was in May. You see that date there, and I imagine we're going to be updating this at least once a year. So this is kind of a living and breathing document. Some of the major changes that I wanted to go through with this document.
Do you want me to get off, by the way, or would you like me to drive? I can do either one. I can either.
If you'd like me to, I'll drive, I think. Yeah.
Yeah.
Let's see. 10, 10.
I know.
5. Okay, because of legislative changes, we updated some of the code here. If you want me to, I can just walk you through the major changes here. We thought it was redundant to add all of this information about the IT security policy because you can go to the security policy to see this. We felt like it was just a little redundant. There's no major changes here in the advisory groups or the responsibilities, except for we added a responsibility that is existing. We worked with Ben Rasmussen, our records officer, and this is quite literally copied and pasted from Grandma and what the responsibilities of a records officer is. What's that?
But I didn't have enough.
Yeah. So we added those responsibilities. We also added a role of record steward, and the intention of this is to improve our record retention compliance, and this is a pretty large job. Record retention is looking at the disposition of records that we create and know what to do with them. Do we destroy them? Do we keep them forever? Do we keep them for 7 years? And State Archives sets those schedules for us. And so this requires just each department within USBE to have a point person because it's quite a lot of work. So that was one of the major changes. Here we go down that we just cleaned up some of this language. There's nothing, I would say, very different in these sections. But I did want to bring up one section that I think is a little bit more of a difference, and it's here. This is the current way things are being done as far as the processing of data requests. Previously, this is how we decided whether a data request would go on the consent calendar or directly to law and licensing. We had a few situations the last few months that motivated us to update this policy. For example, the USBE board leadership wanted to have an agreement with WestEd, and time was of the essence, and we were not able to follow this process, the previous process, and so we wanted to have the reality of how things are processed reflected in the policy, and not just kind of make things up as we go. So like I said, this is a living and breathing document, so we wanted to update that. So we have that new category that USBE leadership board requests data sharing, that there needs to be an agreement, of course, in place, but that approval from board leadership can happen for these requests, that they do not have to come to the Law and Licensing Committee, then the full board for approval. But this doesn't mean that the data sharing agreement wouldn't exist. We would still need to be compliant with FERPA and state laws. The other major change on this that I wanted to point out is right here. We have had a number of internal data requests. For example, a charter school will reach out to us and say, we have requirements to report on certain statistics because of a grant we've received, and we need very high level aggregate data to report back to it's usually a state grant, and having them go through the process at taking the request to law and licensing, and then the full board usually takes a couple of months, and oftentimes they need the data much sooner. And there's several other examples. We have requests that simply ask the number of educators in Utah, which is an aggregate, non-identifiable. We're asking that the data and statistics coordinator, Aaron Bruff, and myself be able to approve these very low risk requests so that we're able to provide that service to our LEAs. But do you have any questions on this?
Board Member Brittany Cummins.
So where is that at on your paper? Where is that?
Yeah,
so are you on page?
What page
9?
are you on for the?
So it's in this.
It's page 9 at the top.
And you're in this box, right?
Yes.
And so when you say aggregate, and so it's an internal audit or sorry, internal data request, and so approval from coordinator. But you just gave an example of somebody from the outside requesting it, and so would it fit under the consent calendar? How does that work?
Yes, the what we're asking for is that if it's an internal request, and that means it would be even from someone from CTE asking for data within the building, or an LEA asking for information that is high level, is aggregate, it usually counts with there's no low end sizes there, that be approved by Aaron Bruff and myself, rather than taking it through this process. And that if it were external and aggregate, we would still put it on the consent calendar.
Clarifying question.
Yes.
So you consider an LEA an internal request? Yes. Okay. That.
And
yes.
If I didn't formally introduce myself, so David Soleil, I'm the data privacy auditor at USBE. If you can just scroll up to the bottom of page 8, Whitney.
Yes.
And the board members can do the same. So you see there, so we did update the definition, hopefully to make it clear. So internal data request, when it says that in that table, it's referring to contracted third-party vendors who perform services USBE would otherwise perform. So if we are contracting someone to do it, it would be considered internal, as anything also that is federal or state mandated or state funded program report, audit, research, or evaluation in the case of, so like an LEA would qualify under that.
I'm not very comfortable with third-party vendors.
That we are contracting. Yes.
So
yeah.
we're hiring
So like
them.
Questar.
Yeah. Oh, okay.
Yeah. That was the philosophy. They're an extension.
But that's only the aggregate.
That's only for aggregate, though, right?
That's right.
Not anything personal.
That's right. These would be just for Aaron and I to make these approvals would be just at the aggregate level. And the data and statistics staff and myself are very supportive of this, because oftentimes folks will ask us for data that is very, very low risk and they need it right away, and telling them they have to wait a month or two is we have some frustrating conversations with the LEAs. Yes, Board Member Belknap.
Okay. I think it might be helpful when you're talking about the low risk that would be done by you and Aaron. It'd be nice to, I don't know, not necessarily write it up, but what's really that low-hanging fruit, and really how high does it go? I think that's something that you could consider thinking about. I mean, it's all aggregated, but, do we, for example, I'm trying to think of the last one we just approved. I can't give an example. I think a discussion on that at some point would be helpful. How high does that fruit go? But more than that, you made a comment which kind of rubbed me wrong. You said we had a quick process with Advanced Ed that we needed to get information to them, and so you've added in here board leadership approval. I don't really understand what is so fast that can't be done monthly, because, and I'll tell you why I feel that way, because there can be movement from this board. Our chair could say we need this on the board meeting, not to wait till the next day for another month. Those kind of shifts can be done at a leadership level.
Yes.
Yeah.
So really, this came out of a request, literally, of board leadership after our June board meeting and before strategic planning. So there was no board meeting, and what we were asking for was for Advanced Ed, is that, or West Ed? Not Advanced Ed. West Ed to do some research to support our strategic planning session on July. So if we
I
had...
read that differently, that they asked us for information.
Right.
No, so we asked West Ed to do some research, but then in order for them to do the research, they needed data from us. Do you see?
Okay,
and
but
so...
that isn't what I heard.
Oh, okay.
Yeah, that's the same here.
No.
No, it's
we're all-
extremely slow.
This is a USBE board request. If you look, it's not an external request. It's the board requested somebody to have that data to do research
But,
for us.
so I'm a little confused. I mean, she's showing it, Whitney, you're kind of showing us these things, and I'm trying to decide, are you making a step and a plan, or are you just showing us examples? And I don't know. Tell me what
Because it did seem like
I thought this
you've
was the plan, and
had-
these were examples of the plan.
Yeah, and then you've had requests, but you haven't been able to, that are time sensitive, and I'm trying to figure out what are those, because that one sounds
So
like it wouldn't go through the normal process because it was...
No, well, that's the issue. If you look right above, you see that we didn't have USBE board requests. This was something that I think when we did the first iteration of this policy, we didn't anticipate board members or the superintendency, for example, wanting to get. Now this is non-aggregate data. It must have been more sensitive. I mean, it must have been lower down. It wasn't aggregate. It was individual level. But it was essentially, so under the rubric above, it would have needed to go to Law and Licensing Committee, or the consent calendar at the very least. But see, we didn't have a board meeting where it could go on the consent calendar. So if the board feels comfortable with either the superintendency or board leadership saying, for our next meeting, we actually need some research and we want to give this data to West Ed so they can do the research to support our strategic planning, then, so frankly, we did this. We did it with, do you see? And so now it would just saying we could do it in the future. But if it's an external request, if West Ed were asking it for their own purposes, they would fall under that external data request. So they'd be in that middle column. They wouldn't have been in the third column. The third
Well, maybe
column,
it's the way it's set up that it's hard for me to
Yeah.
kind
Yeah.
of
Might be. Yeah.
function here, because it seems I understand all that you're saying, and I
Maybe it just
understand
needs to be set up
the West
differently.
Ed. I understand all of that, and now that it was a board request for us, we were
Right.
asking, and I can get that. I that's a little different. This is hard for me to.
But I still feel like the internal data requests, I'm not seeing any time crunch where they couldn't wait a month. And like Board Member Belknap said, we could still put it on the consent calendar. I'm trying to, yeah.
I was going to say, it's not that they can't. I just don't know that they should have to wait, because if it's, when you talk about internal data requests, so it's
So it would be on the
something- it's
consent
defined.
calendar, though.
Not necessarily. So if you go up above and it defines who those people that fall into it are, right? And so it's a limited group of people that are in that category for an internal data request, and it's aggregate data. It's not that it's a time crunch. It's just, this is so simple and there's no need, right? The purpose of all these steps is to protect student data, right? But there's no protection needed, right? We know where it's going, we know what the purpose is, and we know that it's aggregate. There's low risk.
That's not true, because when you have,
Why? Aggregate. Yeah, you look on the left-hand column. It's
aggregate
either
approval from coordinator.
So if it's
But when you have a lot of aggregate data, and sometimes they've got a list a mile long, you could potentially narrow it down.
Okay. But you go
Well,
back
and
up to the
therein
data.
is the approval from the coordinator of data and statistics and the chief privacy officer. So that isn't to say that it would all, if it was aggregate, it would just be like rubber stamped, let's go. We could take those into account,
Okay.
And I think that would be the idea, and maybe in some cases we would say, no, even though it's aggregate, we are concerned about re-identification of individuals. We should take this to the full board.
So would these be third-party vendors? Because this would
In
just
the
be
definition,
internal.
It's just,
Maybe we should define internal. Is
It
it
is.
defined
It's
somewhere
defined
where?
above. Yeah.
Okay.
That's what it was.
I
Michelle,
must have
may I ask
been
another
asleep.
question?
Yes.
Contracted third-party provider who performs services on our behalf. So it wouldn't be somebody.
That they've already got a
So Google wouldn't be able to.
No, they'd be an external data request.
Okay. Because I know that through FERPA they can become a third-party vendor.
And
So
that would
that-
be with board approval. You would go through our entire RFP and purchasing process.
Okay. Michelle and I have different concerns. Will you go back to the chart, please? Okay, so let's go to the PII and the de-identified, okay? Or the de-identified. Okay, so if it's an internal request, you're putting it on the consent calendar. Okay, now that's clear, correct? So you're not gonna go out and do this until it's been consented to? Okay, so if that insight, an external one comes through us and goes through this committee, when I say us, to this committee and goes through the original process. So the third column is that if the USBE, the staff or the board are requesting it, then it can be approved by board leadership. Is that what you just said?
Yeah.
Well, it's the board. If the board requests it, not staff.
Okay.
So if the board
is the
requests
third
something.
is that third category.
Then we don't have to hop back on West Ed and say, oh, well, can we finish our job?
And
This, go ahead.
I see this as a flexibility thing for the board, because as currently written, it is the only way that the board may approve that sort of thing is through the consent calendar. And in cases like the example we're giving, there wasn't the opportunity for a consent calendar because board meetings aren't as frequent over the summer. And so it's still getting board approval.
When you should make them more.
No, I get that.
Yeah,
I'm just
that
trying
was
to
the
get
idea.
clarity. The internal request is going to be on consent. The external, and I'm talking about the PII, the external is going through the full process of coming here and to the board. And then if it's a request by the USBE board, then it can be approved by board leadership can finish the That's all I wanted was clarity on that. Thank you. I can register.
I know it's really far.
I know.
I
This
do
was the best we
just
could
a minor thing under 4.3, the definitions. There's an extra
Yeah,
or, but
I
there's
noticed
nothing
that.
else, so we just need to, because I keep looking for that. I saw that. So an LEA, if an LEA asked, would that be internal or that would be external?
If an LEA asks for data based on a program that was state funded, then
it would be-
and it was aggregate, then yes, it would be an internal request.
But if they wanted data not for a program, that state or whatever, then it would be fall under external.
That's
okay.
So, we had an example recently where an LEA provided us data, like it was their data, they provided it to us, and then they wanted us to provide it back to them for their ease. It was aggregate, and it was frustrating for the LEA that we couldn't just give it to them, that we had to go through this consent calendar. Well, it was an organization. It was the whole thing about so it was related to, the charter school local replacement funding. Districts are required to provide a portion of that funding based on the number of students in the charter schools. So they were trying to identify which students are attending charter schools that are attributed to them versus a neighboring district. There were two districts, anyway, that were very close, and they all go, some of the charter schools have both of these, but they're trying to identify which of those students this district needed to pay 25% of the local replacement for. And so as part of a state program, they are required to pay 25% of this local replacement funding, and yet we weren't able to give them data for them to pay a lot of money to have money taken away from them, really. And so these are the kind of instances we're trying to solve. It's not probably as, I don't know, nefarious or, you know,
Right.
as it may seem.
Okay. Board Member Belknap?
I'd like to make a motion that we approve Board Policy 306 as amended and recommended that the board adopt Board Policy 306 as amended.
Okay, so we have a motion before us. Any discussion to the motion? Nope. Okay, all in favor? Aye. Any opposed? Okay. And I'm voting for that hesitantly. I still need to read this, but really study it, but we're good. So 2.6 and 2.7, yeah. Are you okay?
Okay.
Okay. Okay, so we'll go now to 2.6.
Oh, you can.
Oh, yeah, board docs is really slow. It's really bad.
So 2.6, there are two external data requests. This will never be approved by us if we pass that new data governance plan in full board meeting. So this is external.
Even though they're all in aggregate, still external.
So it would still
Comes
come here.
Exactly,
Yes.
exactly. So we have someone from KUER. They're using, they would like statewide mobility rates over the past 10 years divided into general ed, special ed, resource, and special ed self-contained by the categories. And you can see those categories there. I reached out to Leah Voorhees to see if she had an opinion on this, and she is neutral. Okay. The second request.
Potential media?
You know, I'm assuming it could be potential media. So I don't know what they're going to be using it for, to be honest. Oh, it looks like there's 3 this time. Then we have someone from the University of Utah. This is supported by Dr. Christelle Estrada. They would just like aggregate counts by LEA of the top 10 languages spoken by students at home. And the intention of this is to help, it looks like there's a team there at the Gardner Policy Institute just looking at the diversity of areas by language. And then the third we have here is a parent. She is interested in special education student counts by location. She has not, depending on N sizes, a location might be just at the LEA level because of those low N sizes, but she wants to use the data to see if there's opportunities to provide more behavior training to teachers that are already teaching. So those are the 3.
So maybe we should do one at a time. Okay. So Board Member Brittany Cummins.
I move that we approve the Lee Hale, KUER, NPR Media, Utah, sorry, I'm tired, request, data request.
Okay, so the motion before us is to approve the Lee Hale, KUER, NPR, Utah data request. Any discussion to that? Yes.
Okay, I can't pull it up, so I'm really kind of struggling.
Here,
It's not
do you
your
want
fault.
me to?
And he's there. This person is only looking. I don't know, male or female, because it's Lee. Are they list? I can see it over here, much better than that one. They only want special education and self-contained rooms, and that's it.
It looks like they want. Let me pull that better for you.
I can see it. I'm
Okay. It looks like they want divided into general ed, special ed resource, special ed self-contained. So they want those 3 categories. So general ed would be just the
and just a state
mobility.
So they want the mobility, whether they went homeschooling, public school, transferred out of the state, that kind of stuff.
And what is the time frame that they want from what year to what year?
They say the past 10 years. So I think they're looking at trends.
How much time will it take you to do something like that? To provide this person with that information to maybe do a news story?
Are you asking how long it would take our data and statistics section to put together that table? 15 minutes.
Okay.
Tops.
Really?
Wow.
That's. I mean, just getting
Data and
counts. That's a
statistics,
very.
come in
That's
and
a
tell
very
us.
simple query. I hope they're watching, and I didn't just. You need to.
They
what is
lynch
it?
you when you get down there.
Overpromising.
Overpromise. Underpromise.
Yeah.
It should be noted. Any kind of count is fairly straightforward to do in a query.
Okay. Brittany Cummins, any other discussion? No? Okay. All in favor? Aye. Any opposed? Okay. Motion passed with one opposed. Well, that would be the opposed, right?
That would be me.
Okay.
Sorry. Yes,
Okay, next. Remember.
I move that we approve Dr. Pam Perlick and Mallory Bateman, the Policy Institute data request.
Okay, so the motion before us is to approve the what she said. I'm not reading all this. Any discussion? Okay, seeing none, we'll vote. All in favor?
Aye.
Any opposed? Okay, and then Board Member Brittany Cummins.
I have a question.
Yes.
Okay. So all these data requests coming to the board is kind of new in the last year or so. I'm just curious, is this a normal trend of requests? Like, is this this is a normal number of requests that the State Board of Education has received over the years for data?
We got these last year on the law and licensing, I remember.
We receive more requests than this, but oftentimes the data are available publicly, and so oftentimes it's just pointing them in the right direction rather than producing a new report. But this is, we have at least one or two data requests every day.
Okay. So this is like, it's just awareness of something. All of a sudden you're like, whoa, this is a lot, right? And so, but this is just normal trends of requests from USBE for data and information. I'm sorry.
He answered this question in another meeting with me a couple weeks ago, and it's usually a couple a day.
Do we have to have a motion?
No.
No?
But I do have a question
Yes.
regarding it. And I guess it's, so when, like I said, this is a new thing for me as a board member to see these and to wonder what, under what basis do we make our decisions as we say yes or no on data requests. And I guess for me, as I balance that, it's lack of information is always worrisome, that it's like, if it's just like, I want data, and so it's, and I know aggregate data is fairly harmless, and there's not a lot of risk in it, but it's a decision point for me as a board member now when it hadn't been previously. And so it's kind of like, well, what is the purpose? And so when there's just no information behind it, and it's just kind of, I want some data, then and so maybe we could set some kind of a criteria that if people are asking for data, that there be a criteria of information requested, so that I'm not just left here going, well, okay, sure, have some of this data based on I don't know what or I don't know why. And so that's why I'm not wanting to make a motion on that last one at the time, because it just seems really vague and difficult to understand the purpose and the request in general.
So maybe just if we could ask for you to seek more information on this.
Yes. I did reach out, and she did not respond. Okay. Or he, Kelly.
Yep, Kelly and Lee this time.
Okay. Okay. So I guess we'll move on to item 2.7. R277487, Public School Data Confidentiality and Disclosure.
Okay, and Whitney's asked me to do most of the talking on this one. So we already looked at this during the last Law and Licensing Committee. There are, so maybe I can drive on your computer. So one of the first changes was one that was recommended, well, I guess that one actually comes in a moment. The first change is on line 51 between drafts 1 and 2. This is very minor just in terms of the definition. I believe, as I looked at Angie, that this was recommendation from superintendents to, instead of define the CIS controls, to define cybersecurity framework and then say that that means the CIS controls or another thing. Exact same meaning, just written in a way they preferred. There is the, I want to get to that in a second. I want to show what was actually requested here. So on line 102, because we spoke last time quite a bit about the definition of significant data breach, and this group recommended something to do with the intention. So an intentional data breach that successfully compromises student records would be considered significant, regardless of size or sensitivity of the records. So the other big changes here, and I'll go back up in the definitions because part of it's there and part of it's in another section, is SB 207 requires the board to create rules regarding record retention and expungement of student records. So one of the first things we needed to do was delineate the difference between destroying a record and expunging a record. And so you can see that difference here. That destroy basically means we will follow current industry best practices for destroying data, with the ultimate goal being to render it irretrievable during the normal course of business. Expunge is slightly different and simply means to seal a record so as to limit its availability.
And that's consistent with.
And that's consistent, like in the criminal law system. If you have your record expunged, they're not destroying it, they're simply sealing it so it's not readily available. Okay. So then our next change ends up in around line 185. So that one on 185 is again just slightly based on that one definitional change. The one that should be brought to your attention is striking line 189 through 190 of draft 1, which was the requirement to have an external security audit with every 3 years. We received feedback from, we have our data users group, which consists entirely of LEA representation as our stakeholders, who had a lot of concern with this, particularly from the cost point of view. There was also the interesting fact that was pointed out to us that the reason we've been advocating for the CIS controls is because they're 1 through 20 steps of like low-hanging fruit to last thing you should do. It's prioritize. Number 20 is to have a security audit. So it seemed somewhat disingenuous. The LAs were concerned where it's like, on the one hand, you're saying, use this, it's very adaptable. You know, you can say we're doing 1 and 2, but we're at step 3. But then also every 3 years, you have to do number 20. So it didn't seem to really go with it, and that's why we recommended to have it struck in the second draft. Any questions or comments to that part? Okay, then I will, yes.
Oh, no. I didn't know if anyone.
Okay.
Okay.
The bulk of the new information we have here is between when we last met and now, we have drafted another rule that SB 207 wanted the board to create regarding, as I mentioned before, the retention of student data. And just to go over this kind of, give the idea of where we're coming from, our belief was basically that we already have a records retention law in the state, which is GRAMA, and it seems somewhat strange to have both GRAMA but then also record retention that only existed in board rule. So our philosophy was, so paragraph 1 is basically to say every LEA needs to classify all their records according to GRAMA, and then paragraph 2 is that they will follow that. They'll retain and dispose in accordance with that. Paragraph 3 says if an existing retention schedule doesn't exist, particularly for disciplinary records, then instead of having the board create that, then that records retention schedule should exist. So the LEA would work with state records in getting that retention schedule to exist. And that's basically lines, what am I looking at, 218 through 225. 226 through 227 was something the LEAs wanted to make sure was in there. They're very concerned about destroying records too soon. They have lots of cases where, you know, a student maybe leaves the district for a week, even a year, and then they come back the following week or a year later, and so consequently they want to hold on to certain records with that idea of administrative need until we're certain that the kid has left. And 5 more or less says, unless the data requires permanent retention, then it shall that they will either destroy or expunge the student data after that administrative need has ended. And then one of the other parts of SB 207 was that there needs to be a process for a parent to request expungement or destruction. We saw this as being very similar. FERPA, so the federal law, already requires parents to be able to have access to all the records related to their student, but also they're able to request that those records be amended. The issue with amending is it isn't clear. Does amend mean just change, or could it mean expunge? Could it mean destroy? FERPA wasn't clear, so we are basically taking FERPA's process word for word, the inaccurate, misleading, in violation of the privacy rights of the student. That is exactly what FERPA says, but just clarifying that amend can also mean expunge or destroy. And that the process which a parent would use in, so paragraph 7 there, where it refers to 34 CFR Part 99, that is the process that already exists in FERPA for a parent to seek to amend a record. So really all we are saying is use that exact same process, but that process could lead to expungement or destruction of a record. And then the last bit that is worth talking about, which was in draft 1, but I wanted to clarify as we're talking about draft 2, is, where is it exactly?
Are there any questions on that expungement part?
Well, I know that
before we go on.
Yeah.
Board Member Hanson asked for an amendment just to on line 418 add or expunge. I think she said that she would feel better if that was added in there, because as a parent, I'll be honest, I wouldn't even know that amend would mean that I could ask for it to be expunged or destroyed, and maybe we should put that in there, that amend, destroy, or expunge. I don't know.
Certainly. But just to move up, so this entire section, though, because this is the section related to URAD.
Right.
And so, as many of you are aware, SB 207 requires the board to enter an agreement to share records with URAD. But then so the bone it kind of throws you is that it does say that you are to create rules regarding the protection and maintenance of those records. This was really our attempt to get at that, based on certainly input from Board Member Hanson, but also just kind of the general feel that we have gotten in hearing the board's concerns with URAD. I will throw out there also, it's been in the news recently that there was a whistleblower issue.
Yes, and
with
she won
URAD.
her case.
I think there are some very big concerns regarding their ability to protect the data that we share with them. I feel like last time when we looked at this, it was at this rule that we are proposing, the feeling was just kind of, oh, we have to do it, the legislator's making us do it. This is not that. This is a rule that you can put more teeth in, is how I would interpret SB 207, saying you make rules regarding protecting and maintaining. So this is what we came up with. So I can answer any questions regarding some of the details in it, or I could continue just going over the details.
If you don't mind me having a point on this as well, after talking with Board Member Hanson, we wanted to make it clear that this is not the agreement, the data sharing agreement with URAD. This is just setting up the framework, meeting that legislative requirement to have a board rule on this. The agreement is a separate negotiation as far as the restrictions, the use, the scope, the destruction, the collection of the data. And that's where we want to be a little more restrictive and prescriptive of what they're going to do. And so we didn't feel like a board rule was the place to put in those restrictions. Just so you know, you'll have the opportunity to look at that agreement. They haven't asked us for one yet, but I expect they will.
Okay. Any other discussion?
Okay. I move that we approve R 277487 Draft 2 on first reading and recommend it to the board for approval on second and final reading.
Okay. So the motion before us is to approve R277487 on first reading and recommend to the board on second and final reading. And then I just wanted to add in Board Member Hansen's amendment for line 418 to add or expunge. After amend, sorry. So any discussion to that?
Well, the motion was made.
The motion was made, yeah. Yes.
So in the definition of amend, you used both the words expunge or destroy. Is that correct? Would that same apply here?
It is not defined in the rule.
Okay.
So,
it's just adding clarity.
And that on 418, that again is basically just saying that the FERPA rights that would normally apply to a parent being able to have access, that's actually 4A is saying that a parent should have access to it. So we're saying a parent also has to have access to their kids' information in URAD. We are treating them as an extension of USBE in that regard. And then paragraph 4B is doing the same, is that same right to amend, but it is, in this case, I would say separate from what we were just talking about a second ago. So we could include that same reading we were looking at in terms of our LEA expungement policy. So it would say amend, expunge, or destroy as you all see fit to handle the amendment.
Yeah. I'm good with adding amend, expunge, or destroy.
That's a question. So if this data is shared, so USBE shares some data on January 1st with URAD, and they hold it, and a parent asks for a record to be amended at USBE, but they're holding January 1st data, and now we've got February 1st data. What's the process of ensuring that data crosses over and anything that's changed here is changed there, or et cetera?
I think that is one of the details we would work out in the agreement.
In the agreement. Okay. So any further discussion? So just to, we would add in 418 after amend, it would also read or expunge or destroy. Okay. Seeing no other discussion, all in favor? Aye. Any opposed? Okay, motion passed. So now the motion will be to send R277487 on, to accept R277487 on first reading and send to the board as amended for approval or for acceptance on, for approval on second and final reading. Yeah.
Thank you.
Thank you.
Oh, wait, we have to vote. All in favor?
Aye.
Aye. Any opposed?
Now you're out.
No. Okay.
Thank you.
So motion passed unanimously. Let's see. Now we're going back up to 2.5, right? R277516. So that is Ben.
Ben Rasmussen, Director of Law and Professional Practices. This is before the committee following a request from Board Member Joel Wright that we address a provision that's contained in the federal ESSA law. That has a provision that requires each state to adopt in statute or regulation language regarding what's been proverbially referred to recently as passing the trash. And so the federal statute included language that talks about an LEA facilitating an employee to get a position at another LEA if that the employer has knowledge or has reason to or probable cause to believe that the employer has engaged in sexual misconduct, and then it has some exceptions for that. I think we have a situation where we have a number of laws that deal with this in different ways, but we wanted to, or what's proposed is that be included in rule the specific language that's included in the federal ESSA statute, just to make it clear that we're in compliance with that requirement. And so section 9, which begins on line 222, is where we've basically set forth that language out of the federal statute verbatim, except for modifying it just a touch to comply with our style guide. But that's what's proposed here, and I'll be happy to answer any questions you might have.
Okay. Any questions?
So when ESSA came out, as staff, we did discuss whether or not we were in compliance with this section and whether other sections of board rule and statute already covered this. And there's a section in code, and that's why it's actually attached to board docs. It's 53E dash, it's not 53E dash 3 dash, it is it 53G? Well, okay, so I guess I have the wrong section up listed up there. But there's a section of code that was amended this last session and it's about reference checks. So there's already a statute that requires LEAs to provide reference checks, which is a specific way of essentially stopping, people from moving from one school or one district to another. And last session it was amended. It used to say, provide the information to the best of your ability within 20 days. And now that to the best of the LEA's ability has been stricken from the statute. We also have, of course, many of our rules which require mandatory reporting here. And so this ESSA requirements a broad statement about not assisting or allowing or aiding or abetting people from moving from one LEA to another. But there are other more specific sections of code and board rules that address this. And I think, as Ben stated, the request from a board member was to take the exact language and make sure we actually have it in our board rule, and that's what we've got. So,
did you want to have discussion?
Okay. Oh, we do have one public comment, so before we make a motion.
Well, she has a question.
Yes, ask your question.
Yeah, because this just seems really broad, because there's a difference between assisting someone to get employment and just turning a blind eye. And so I'm guessing that is captured under other places in state law.
In what way?
So if you know that somebody that you have employed has done something, has engaged in sexual misconduct regarding a minor student, right? So you know this. There's a difference between, I'm going to help you find another job, and I'm not going to look. I'm going to fire you, and I'm going to look to the side, and I'm not going to tell anybody else what I know.
There are other requirements in
So
state law.
there are,
report to the board,
exactly.
report to
So
law
there's
enforcement.
yeah, so there's all kinds of other
this
laws
yes.
that capture all of those things. This is just very general and specific. Okay.
Okay, Tracy, in 2 minutes, can you?
So, I kind of have two problems with adopting this amendment to the rule. One is sort of what we just went through with the data agreement, when it's already in another section of code, just adopting that code verbatim That's not usually something you do, and it would be a specific exception for this rule. And the other problem I have if we do that is there's no definition of probable cause. There's no definition in the U.S. Code of probable cause, how that applies. And I think if we didn't allow Brian or Angie or Ben to comment, I think it would be hard for even this room to distinguish between reasonable suspicion and probable cause. And so if you are adopting the federal code into the state regulation, I think you have to give a definition of probable cause, because now you're adopting it. And what it does is it says, I mean, we, like Angie said, we have other things like in the statute that Angie was referring to, 53G 11410, the LEA applicant must request that the LEA applicant's most recent qualifying position employer disclose information regarding any employment action taken or discipline imposed. So that's a for sure, as opposed to this, you may have probable cause. And I'm concerned about imposing that probable cause requirement on an HR personnel or someone that doesn't really have the way to distinguish what's probable cause, reasonable suspicion. I think maybe nobody's found out, but I shouldn't pass this file along because teacher A said, I don't feel comfortable around teacher B. I mean, because then we're crossing over into sort of a tort, which there's some immunity, but there's ways around immunity, which is intentional interference, and you're not complying with the law. So I think if you adopt this, you're going to have to define probable cause and then also be able to distinguish the exceptions to the probable cause. And I think with the mandatory report, you sort of don't need that.
As long as we can see it.
So.
Okay, thank you. And then Terry Shoemaker, did you still want to make public comment on this?
Is this the latest version of this? Okay. Terry Shoemaker, when we discussed this briefly with the Utah School Board Association, Utah School Superintendents Association, I do agree with Tracy that there's going to be some confusion amongst administrators who have been trained in reasonable suspicion and the language of probable cause. And I've suggested that maybe the way to deal with that is to add one, maybe add reasonable suspicion there, two, but it might make it worse. And Tracy might say that might make it worse. I don't know. All I know is understanding probable cause in the legal term is different than the training that's been given to school administrators and district administrators on what their standard is for their type of investigations that they conduct, which is the standard of reasonable suspicion. I just think it needs further discussion. Thank you.
Okay, thank you. Okay. Board Member Brittany Cummins.
I move that we table this rule to come to the determination if it's necessary to make these amendments.
So can we table it for today, or
like
okay.
like I
so
think
it come back
bring
next
it back.
month?
I think I just say if it doesn't need to come back.
Okay.
So maybe that's not tabling. Yeah, table it. You can table it and never bring it back.
If we want table it to see if the changes would be relevant.
Yeah, if by law it's necessary, or if it adds value to LEAs to gain understanding of what the law is, but if it's going to confuse or conflict or create other problems or be just downright repetitive of something that's already there, then I would say that it's not even a necessary amendment. So I would just say table it until we distinguish the necessity of the amendments.
Okay. Did you have something to add?
And just to clarify, because I don't know if I was very clear with what I said earlier, we as staff looked at the provision in ESSA a while ago, over a year ago, and we felt like the laws and rules that we had, we were in compliance with that. But again, this was just a specific request of a board member who saw what another state had done, which may not have, that other state may not have the sections of code we have or board rules that we have. So I don't think that we're going to come back saying that this is necessary legally, but I just want to make that clear. It was a request of a board member.
Okay. Okay, so the motion before us is to table this to look at necessity.
So,
Oh.
okay, well, maybe we didn't, okay, we didn't make a motion.
Yeah, but it will be in full board even if we table it. He would then still.
Right, the motion is to table it.
So I guess since we didn't make a motion in the first place, there's nothing to table, and so I would say we just don't take action on this particular rule until we determine
Okay,
its
that's true.
necessity.
There is nothing to table. Okay. No action. Okay, item 2.8, R277-444, distribution of money to arts and science organizations.
So maybe since Kathy Jensen and Ricky Scott aren't here, you could move to 2.9 since Jennifer Thrunson is here.
Okay, so we'll go to 2.9, dyslexia handbook.
Good thing you got here, right?
Okay. Okay, go ahead, Jennifer.
Jennifer Thrunson, Teaching and Learning, Pre-K 12 Literacy and Library. I am here just to present to you the dyslexia handbook created by the Dyslexia Task Force as charged by the board. We have worked on it for, I want to say, 18 months. It has been a long, long process and come to fruition, but really should be a great resource for our state in supporting students who struggle to learn to read, especially those with dyslexia or other reading difficulties. So it's just basically here for your action in terms of approving the content in the handbook for future development in terms of graphics, but distribution to the field as parents, educators, and other stakeholders interested in supporting students with reading difficulties.
Okay.
And there's lots of stakeholders in the audience that helped as part of the committee. So Carrie Atkinson is our lead on this. She's been a great representative. Jen is here, it looks like, with her two daughters. Is that your daughter, Carrie? I haven't met the children. Susan is here as well. She's a principal in Salt Lake District. Kim Fratto up in special ed was on the task force as well. Baby's here, so they're kind of a crew, and they also have children who suffer from dyslexia, and helping to help educators and others become informed about what types of screening, what types of instruction are best to really help students who struggle with reading difficulties.
Okay, Board Member Belknap?
I was actually going to ask that they introduce themselves, but I'd really, if the parents are okay, I'd really like your kids, because we can't see them all, if they'd stand up and tell us their name and what school they go to.
Let me give them a big mic.
No, yes,
yeah.
Please help them. We'd love that.
This is Sarah Atkinson, and she goes to Middle Canyon in Tooele School District.
Thank you.
Thank you, Sarah.
Emmett,
And where do you go to school?
West Elementary,
And what's your grade level?
4th
Fourth grade.
grade.
Thank you.
My name is Walter Peachum, and I go to West Elementary, and I'm in 5th grade.
Okay, older. Let's come up to these two ladies.
I'm Allison Price. I go to West Jordan Middle School, and I'm in 8th grade.
What was that?
My name is Isabella Price, and I go to Midas Creek Elementary, and I'm in 6th grade.
That's the best part of the whole day, okay? Anytime children are here. So thank you. And I'm sorry I made you nervous over there. My question would be, we have this handbook on dyslexia now that's created. Do we have others with diagnosed issues for children? Do we have other handbooks like this?
Not that I'm aware of. I'm looking at Kim just from a special ed perspective, but no? Okay.
So I'm just going to ask the question then, why this one, and why don't we have others?
Okay. Carrie, you want to come speak to that? I think it'd be a great voice. Yeah. If you don't mind me inviting her to the table.
You have to ask
chair member.
Yes, that's fine.
My name is Carrie Atkinson, and I sit on the Access Committee, and I'm also a founding member of Decoding Dyslexia Utah. I requested this before Access Committee because we were attempting to address gaps in education. And one of the gaps that I've identified as a mother of 3 children with dyslexia and as a person with dyslexia myself is that we're not meeting their reading needs. Whether they are in general education or they're in special education, they're not getting the instruction or the accommodations that they stand in need of. 16 other states have a dyslexia handbook, and we would become the 17th state if you vote to move this forward. The other states I've spoke to have benefited greatly from informing both teachers and parents. A common scenario as a parent is I go and I meet a teacher and they say, oh, we don't recognize dyslexia. We don't test for dyslexia. We don't deal with dyslexia. And there's immediately a communication barrier because they're saying specific learning disability and I'm saying dyslexia. The handbook would inform both sides of that conversation. And the next thing is I had a wonderful first grade teacher who said, I don't know what to do. Tell me. And then it was on me as the parent to go find all the resources, tell her, and then she advocated for me. This would give both sides the resources. It also brings in all the experience and expertise in State Board of Education. It says these are the best practices in tiered systems of support. We have DIBELS. This is how you use DIBELS. We have all the tools. We're just not using them because they don't know about them.
Okay. Did you have anything else, Board Member Belknap?
I just love the little graphic right there, educators plus parents equals student success. And I think that's in any setting, not just with children with dyslexia or in any of them. I'd like to make a motion.
Okay.
Thank you, Chair, that we approve this dyslexia handbook. I don't know that we have to have it on first reading, just approve it, and do we send it to the full board for final approval?
Okay, so the motion before us is to approve the dyslexia handbook and then send to the board for final approval. Any further discussion to that motion? Seeing none, we'll vote. All in favor say aye.
Aye.
Aye. Any opposed?
Happily
Okay.
aye.
Motion passed unanimously.
Thank you.
Okay, and I see that Ricky Scott is in here now, so we will move to our last item, 2.8, R277-444, distribution of money to arts and science organizations.
Yeah, go ahead.
Go ahead.
So I'll just start and give a little summary, and then these 2 lovely people can explain why they asked for some of these amendments. The rule has you'll see that there are 2 sections of the rule that have been deleted, and my understanding is that those 2 programs are no longer funded. So this is a program where we receive funding at the State Board of Education that then is distributed to multiple organizations that support arts and science, such as Thanksgiving Point, the Leonardo. I mean, you guys could probably name, there's many organizations that receive this money and then support our students. And so the 2 sections on page 10 and 11, they're no longer necessary in the rule because we no longer receive money for them. Then the other requests were to eliminate some deadlines that either worked for one program but not the other, and to allow the staff to establish those deadlines through the application process. Did I describe that correctly?
That is absolutely correct. Then one other addition is that some of the arts organizations, specifically Tanner Dance and Ballet West, have asked for the opportunity to be approved to do some distance opportunities so that they can include more students than might be able to come to the venue through some sort of a internet broadcast. So we wanted to make that explicit in rule.
Okay, Board Member Brittany Cummins.
And sorry, I was trying to find that spot. But
it's in 44.
On 44. Okay. But that's in addition to, right? So they're not going to cut back on what they're doing just to provide things distance, right? Is that correct?
That's what we requested, was that it not supplant other opportunities.
Yeah. The language says and may include, so it seems like it would mean in addition to. Yeah. Yeah.
Now just looking at this again, this is me, and everybody knows every time I look at a rule, I'm ready for more edits. But I think actually the way it should state is we should have this be a 6A at the top on 38, and then those would be little I and 2 little I. And then we'd do a new B that states an educational service may include, distance experiences, so that it's still supposed to relate to an arts or science core standard and take place in a public school or professional venue or facility. And maybe we need to say except as provided in subsection B. I've just got to work on the structure. If you don't mind, I'll just fix that.
But yeah.
But yeah.
Okay. Are you ready to make a motion?
Yes, and a comment too, please.
Okay.
Okay, I just want you to know how much I love these opportunities for the science and for the pops to come out and do different things for people. It's amazing that kids are touched that could never have the opportunity to have these because they don't live on the Wasatch Front in Salt Lake City. So anyway, I love it. I would like to make a motion that we that we approve our 277444 on first reading and send to the board for approval on second and final reading.
Do we have to say as amended?
As Angie technically amends it.
Angie's going to technically amend.
Thank you.
Okay. So we have
two. It'll be a draft two.
So it'll be draft. Okay. So we have a motion before us. Any discussion to that motion? Seeing none, let's vote. All in favor, say aye.
Aye.
Any opposed? Okay. Motion passed unanimously.
May I ask one other question?
Yes.
My question is do we have any other programs that are wanting to jump on board right now? Are there any pilots going on?
There are no pilots. We don't have funding for provisional programs.
Okay.
So if the legislature were to specify specific funding for other provisional programs, we would put out applications and welcome applications, I believe, to both programs. I have programs who have expressed interest.
Okay. I just wondered
Plan
if
B Theater is one. Just
okay.
as an example.
Do you have some?
With IC, yeah. We now, starting this year, the Ogden Nature Center has recently been added as a provisional member as well.
Oh, so it's a provisional this year?
Yeah,
oh,
so
awesome.
they're building their capacity in the next few years to be able to do their outreach to all their schools. They're really good regionally now, so now they're building to be able to reach the entire state.
Awesome. Thank you.
We're excited for them.
Thanks to both of you.
Okay. We're done.
Do we sing now? Amen.
Yeah.
I'm not on mic.
You might be.
We hear you on the recording.
These mics are actually better than you think.
No
Do you do the motion to adjourn, or you don't need that?
I guess we will adjourn. Meeting adjourned.